19,
don't worry.
kindly
Madam,
upgrade.
it's a compassionate appointment, madam. Item number 200 of today's list.
200.
Madam.
Matter it was in the list is 561. In the December it was on the top.
We upgrade. No upgradation at all. Chalo, document.
Alert, I am mentioning
Madam,
alert inclusion of your lordship's list. मतलब A category scale of pay the petitioner. Inclusion.
Contempt application. देखिए audit. Wait.
Lord, may I be permitted to grant leave? My lord, yesterday night I have been served with a transfer order in Purbo Bardhaman from one circle to another circle around 100 kilometers. My
I'll
son is,
release.
my lord, kindly visualize, my son is
Lordship, may I be-
suffering from hemophilia.
No.
And my lord,
Lordship, may I be allowed to mention
File
on
it,
matter
file
for
it, get
inclusion
his
in
number
the
first.
my lord, next
No,
Tuesday,
no
my lord,
leave. No.
my lord,
Yeah.
Wednesday.
Lordship, may I be allowed to mention on matter for inclusion in the list, your lordship?
Milord, this is the third time mentioning Milord. Mentioned this matter yesterday, Milord. Extreme urgency, compelling circumstances. The petitioner they have been ousted from participating in a recruitment process, Milord, due to age bar, Milord. This recruitment process deals with Milord para teachers, Milord, appointment as
What did I tell you?
Milord, compelling circumstances, Milord.
Please
Kindly,
don't
kindly,
embarrass
Milord,
the
compelling
every day
circumstances.
you will come and mention.
Milord,
No,
compelling circumstances. Milord, kindly appreciate.
Don't do it.
My lord, I will file it. May I give the number, my lord? May I give the number? My lord, kindly
Please
visualize.
file
My lord,
it. It will
chairman
be
has no
listed.
authority.
We'll take it up serially. Why are you worrying? Yes.
My lord, transfer matter, that is why it is urgent.
Transfer matter, we have a definite date to take it up. We'll go serially. Why? There are other matters also. Yes.
Lordship,
The petitioner.
I am for the respondent for the NIOS.
Directed to sub notice to Mr. Shiv Shankar Banerjee. Carrying for the
What is this matter?
happy item for the wallet NIOS.
My lord,
Lordship, I'm appearing, my lord. I'm appearing.
My lord, may I seek indulgence to appear for NCT, lordship, online. For NCT, I'm appearing, lordship, in this matter.
Yes.
But here the petitioner appointed as a assistant teacher in the year 1995.
Yes.
After that, my lord, the petitioner appeared taken examination in the year 2017 at the course, my lord, before the my lord, National Institute of Open Schooling. And I passed the examination. Page 39 is the mark sheet of my lord, DLED training.
Yes.
By the National Institute of Open Schooling. My lord, I am praying before your lordship. My lord, I have mark sheet. My lord, till today they are not issued my certificate, pass certificate. For that reason, my lord, I am unable to apply for A category scale of pay because there is a
NIOS or NCT?
my lord, from NIOS.
NIOS. My lord, NIOS, I have not issued it because the criteria is he has to be class 12 pass before he passes the exam. And here, if you see that he passed the class 12 exam only in 2020 and he completed his course in 2019.
Oh, that will be decided at a time when the A category scale will be considered by the appropriate authority. So far has
No,
the
Lordship,
DLED course is concerned.
my case is I will only suppose I am admitting someone for graduation, but then I will say class 12 has to be passed. And suppose I've given him a provisional admission pending review of a paper. Then Lordship, in the review it is found that he failed. Then can I give him a graduation? So Lordship, my criteria is, if your Lordship so wants, 22nd Lordship, 22nd September 2017, the criteria says that he has to be class 12 pass with 50% before he is awarded with this degree. So that he was not. If your Lordship allow me to file
Where
a
is your
small...
pass certificate then? 50%?
Well, that is page 39 mark sheet. I am not praying before your lordship A category scale of pay. I am on certificate.
That's right, but
That
I can
pass
only issue
certificate is
certificate.
subject to verification of class 12 mark sheet.
Yes, that is my lord. I already annexed senior secondary page 37. Case
If your
37.
lordship,
Mr.
can you
Banerjee,
see, he
case
passed
37.
it in 2020
Yes.
and he passed my examination in 2019.
Okay.
So I cannot allow him this certificate because he has to pass before my decree. He has to have 50% marks in class 12.
Where is that clause?
Lordship, if your lordship kindly 22nd September 2017 circular. If your lordship wants, I will file it a small affidavit. Give me a week's time, lordship. Lordship can decide on that.
Mr. Shiv Shankar Banerjee, learned advocate, appearing for respondent NIOS, submits that the petitioner ought to have passed higher secondary examination with 50% marks prior to the declaration of the results of DLED online course by NIOS.
My lord, not prior, after. Prior is required. He passed after.
Prior is required. That is
Yes,
what I'm recording.
Yes, lordship.
Yes.
Yes,
Prior to declaration of the result, he or she has to pass.
lordship.
However, in the present case, the petitioner has passed the higher secondary examination after the declaration of the results. He seeks to file an affidavit in opposition to the writ petition. Let such affidavit in opposition be filed within a period of 2 weeks. Reply if given.
My lord, I am appearing for. My lord is mute. My lord, kindly. My lord is not audible.
Can you hear now?
Yes.
Yes.
Now I can.
Yes, what is your prayer, sir?
Lordship, I have not getting my DLED certificate. I have
This is
obtained the provisional
Mr. Banerjee,
certificate
this is also the same.
from NIOS.
Lordship, same thing, Lordship. If your Lordship allow me a week's time, Lordship, I will find out why he has not been allowed.
On the last
Okay.
occasion, Lordship was directed to serve
By the
notice
present
upon the NIOS.
petition, Mr. Siv Shankar Banerjee, learned advocate, appearing for respondent in NIOS, seeks accommodation, take proper instruction. Please this matter. When is the other matter coming up? Which date I fixed? What
Lordship,
come upon not on 16th, 30th January.
Lordship,
30th January.
Lordship, I'm deeply obliged.
On the next date, let him come with the certificate. It's merely for verification. From 2019. After the certificate is issued, from that day, I'll be given grade A, and thereafter I have to come to the honorable court again.
It's perfectly all right, Mr. Lahiri. If he is entitled, I will come with the certificate. And
Yes.
if he is not, then I will come with the reason why I'm not giving.
Yes. That. Item number 6 is the item number 6 will also be same.
Yes, Lordship, item number 6 also, Lordship can pass the same order.
You are here. You are for the petitioner.
I am for the petitioner. I think Mr.
For the-
Banerjee is for-
Appearing only. What do you know?
Same order for the 6.
I'm obliged, man. I'm obliged.
Okay, 6 is order, same order. Raghanar. Chalo.
6 से उठा दी slip कर
I just in 6, my lord, I have for the.
It will appear on 30th. Good. ঠিক আছে এটা কত নম্বর 4
My lord,
Deep Shikha Kuklu. What is the information?
kindly recall that, my lord, a child was not being allowed to.
Where is the state?
For the state. I talk with DEO. My lord, as per DEO, there is no role of the school authority. Only approval. DI is approval granting by the school authority. Earlier occasion, DEO talked to with Deepshika Kundu and school management, but he failed because there is no role of the state.
I have not asked for the merit of the writ petition. Why the child is not being allowed in the school? That was the report
The
called.
school presence is required, my lord. Managing committee or school. I talk elaborate.
Mr. Banerjee,
My lord.
I grant you liberty. You file an application. You have filed.
Fine, my lord, I have also served.
Affidavit of service, my lord, unfortunately has not been afforded, but I have sent copies. Supplementary touch. You have informed the school authority.
Not the school authority, the district child protection unit, where the school
My lord.
appeared and also gave the consent that they will allow the child to attend the school.
Yes, my lord.
Now you say that the child is not being allowed to attend the school.
My lord.
Let the district unit,
My
child protection unit, take a call on your complaint that this has not been complied with, since there was a submission on the part of the school that they will allow the child.
My lord.
Huh?
My lord.
That is what I have recorded in the earlier order, that collaboratively they will
Yeah,
function so
my
that
lord.
the education of the child is not hampered. So
I'm
far as
grateful.
merits of the writ petition is concerned, we can decide afterwards.
Afterwards.
Let this be decided with child
I'm
protection unit. Huh?
most obliged.
So not the school, but I grant you liberty to make a comprehensive application before the child protection unit, or with the contention that the child is not being allowed to attend this. Huh?
Grateful, my lord.
Mr. Devashish Banerjee, learned advocate for the petitioner, seeks accommodation to file supplementary affidavit in terms of order dated 2nd January 2025. He seeks liberty to file application before the district child protection unit since the minor child of the petitioner is not being allowed to attend classes in the school. Liberty is granted to the petitioner to take necessary steps before the district child protection unit. Mr. So-and-so, learned advocate for the state, seeks to file a report on the returnable date. State is directed to furnish a report. এটাকে 30 তারিখে রাখুন। Within this period, on 30th, within this period, you file an application. And what is the fate of that? How it is going? You inform the court. You also take instruction and file a report accordingly. What are the steps taken? And thereafter, we'll take the merit of this writ petition.
My lord,
You take this back.
kindly record the school may be paging, my lord.
You have served upon
My
this.
lord, I have, my lord, this is the affidavit of service unaffirmed, but I have already, my lord, intimated the school authorities.
School pageants is required, my lord.
Even thereafter,
Let a
my lord,
notice
I
be
will-
served upon which block
Principal.
development officer is this? Let a notice be served upon the respondent number school is
my lord, respondent number 11.
Secretary.
11 and
11. Chittaranjan, no?
Yes, ma'am.
Chittaranjan English Medium School be served through block development officer. Which block?
My lord, this will be Gangaram.
Gangarampur block.
Gangarampur. Through block development officer Gangarampur. Huh? Stop.
নোটিশটা যাবে through BM.
ওইটুকু ওপরে দিয়ে দিচ্ছি 30 তারিখে আসবে নিবে।
থানাকে দিয়ে করলে ভালো হয়।
Okay. Through the block development officer, you serve a notice upon the school.
Grateful, my lord.
Let us see.
Madam, I prefer petition.
Yes.
In this matter, I am led by Mr. Molay Krishnadev for the state respondent.
But the petitioner here
I am for the
claiming
state.
the petitioner is paying my lord A category scale of pay, my lord. But for his B.Ed qualification, my lord, the petitioner was appointed as primary school teacher, my lord, under Disciplinary School Council, North 24 Parganas, my lord, in the year 2021, my lord. My appointment letter is at page 65, my lord, and my B.Ed qualification, I have annexed my certificate, page 64, my lord. That petitioner is claiming
Page?
the 65 is the appointment letter, my lord, and 64 is the B.Ed qualification, my lord. But the
No, DLED course?
no, but B.Ed course, my lord. As per the judgment of the Honorable Division Bench is Waliur Rahman, my lord, the other similarly situated candidates were permitted to grant A category scale of pay, my lord. Considering the same, my lord, the other honorable coordinate benches, my lord, directed the petitioner to approach the Commissioner of School Education, and Commissioner of School
Yes, my lord.
Education directed to take decision, my lord. Page 70 is the order passed by the honorable coordinate bench, as well as page 73, my lord.
Others have been granted.
My lord?
Others have been granted.
Yes, my lord. The Commissioner of School Education was directed to take decision. Page 70 and 73 are the order passed by the honorable coordinate bench.
But 70, which you have annexed at page 70,
My lord.
the facts are different.
Different, but 73 is the similar to the facts of the present case, my lord.
June. Which for the state?
For the state.
Come to page 74.
Yes, my lord.
In that case, there was a submission made that the modality of 6 months breach course has not yet been formulated.
But now, my lord, it has been formulated.
Then how this will apply then?
But it has been formulated presently, my lord, and the last date of the registration is 19, my lord, that other matter which we have mentioned, my lord. Now it has been formulated, but despite not completing the 6 months, my lord, the other candidates are getting the, my lord, already getting the A category scale of pay.
No, but this will not apply in your case.
Yes, my lord.
Since the modality has already been
Framed by the NIOS.
At that point of time, the modality was not there. The court allowed the
Yes, my lord.
application.
And since that the Honorable Division Bench has granted the similar benefit, notwithstanding the completing the 6 months breach course, my lord. Considering the same, my lord, the Honorable Coordinate Bench directed to make an representation before the authorities, and the authority.
So you take admission in the breach course as per the order of the Honorable.
Yes, my lord, but the similarly situated candidates, my lord, who have not completed the breach course, my lord, they are getting, my lord, the A category scale of pay, my lord, from the date of their joining.
Yes.
I have not received any instruction yet, my lord. My lord, I have not received any instruction yet.
You have taken admission, no?
My lord, I have not taken yet to take admission, my lord. 19th is the last date, my lord. But the subject to correction, my lord. But despite not completing the 6 months, my lord, the Honorable Division Bench has directed the authorities to grant A category scale of pay, since the similarly situated candidates, admittedly, 3,000 something candidates were already teachers, were already getting A category scale of pay, my lord. Considering the same, my lord, the Honorable Division Bench has directed the authorities to extend the similar benefit to the candidates having B.Ed qualification despite not completing the 6 months breach course, my lord. And upon considering the said,
that was given because at that point of time the modality was not there. Now the modality is there. You say that it is there.
Yes.
So why they will be granted? You first complete that.
But I was appointed in 2021, my lord. But the similarly situated candidates are already getting A category scale of pay, my lord. But now, after the decision of the Honorable Supreme Court, my lord, the modality has been framed, my lord.
You need to comply that.
Yes, my lord, but that cannot take away my right to get A category scale of pay, my lord.
But if you cannot complete 6 months, then your service will go.
Yes, my lord, but that, my lord, I will take admission, but the A category scale of pay, my lord, kindly appreciate, my lord, state is granting A category scale of pay to the similarly situated candidate, not
your circumstances has changed with the modality being framed.
Modality, my lord, it is not, my lord,
it is only on the ground that there was no such modality. The court has granted liberty to file representation. Now the modality has come.
It is not relevant subject to marriage correction, my lord.
How?
But the similarly situated assistant teachers, despite not completing the 6 months breach course, were granted A category scale of pay, 3,000 something teachers were granted A category scale of pay, and considering the violation of Article 14, the Honorable Division Bench has directed the authorities to extend the similar benefit to the appellant, and which was followed by the Honorable Coordinate Bench. But I shall that judgment passed by the Honorable Division Bench, my lord, in Waliur Rahman, my lord, it appears, my lord, admittedly state filed an affidavit, my lord, where it appears, my lord, 3,000 something candidates were getting A category scale of pay, my lord, despite not completing the breach course, my lord. Considering that, my lord, the Honorable Division Bench had directed to grant similar benefit to the appellants.
You have taken admission.
But that have to take instruction, my lord. Already, my lord, the 19 is the last date, my lord, I shall take admission, my lord. Or perhaps, my lord, I have taken admission. But let the commissioner take a decision, my lord, whether, my lord, I am entitled to get the A category scale of pay. Considering the order passed by the Honorable Division Bench, which was followed by the Honorable Coordinate Bench, my lord.
No, sir. You take admission, complete the breach course, and then apply for A category scale. That date will be fixed. Which will be the date? for getting the A category scale. At that point of time, there was no modality. The court has passed order. You consider the representation.
Yes, my
Now the case has changed.
lord. The facts is identical, my lord.
How
My lord,
identical?
but whether the morality has been framed or not, my lord, it is immaterial since, my lord, admittedly, my lord, several candidates were
It
getting.
is not immaterial. It is a material consideration because court has considered that at that point of time, there was no scope for the applicant to take a admission and complete the bridge course in compliance with the order of the Honorable Supreme Court in Devesh.
Yes, my lord.
Devesh Sharma. Now the circumstances has changed. You comply the order of the Honorable Supreme Court by taking admission. After you pass, then you can apply for A category scale from which date it will be applicable.
But there are several candidates who are already getting, my lord, despite not completing the 6 months bridge course, my lord.
That they will take care of.
Then I shall place the judgment of the Honorable Division Bench, my lord, on the next day, my lord.
You have not annexed.
It is not annexed, my lord. It is quoted, my
What is this judgment? This is
Waliur Rahman, passed in MAT 1038 of 2024. It is quoted in the order passed by the Honorable Coordinate Bench, my lord. Judgment dated 30th July 24.
please the judgment will see.
Yes.
By the present writ petition, affidavit service filed on behalf of the petition is taken on record. By the present writ petition, the petitioner seeks for A category scale of pay. You have filed a representation.
No, my lord, I have not made any representation, my lord, but
From the date of her appointment in the post of assistant teacher in primary school under the District Primary School Council, North 24 Parganas. Mr. Onindo Bose, learned advocate for the petitioner, submits that the similarly circumstanced candidates have been granted A category scale of pay pursuant to the direction of the Honorable Division Bench in Waliur Rahman and others versus the state of West Bengal and others. within bracket in Mat 1038 of 2024. He seeks accommodation to make further submissions. List this matter on 30th January. State is dated one is a report on the returnable date.
Same হবে।
Same.
But even also my lord, the category similar my lord matter.
Same auto cool.
7, 8, 9.
8 I am mapping for the state, madam. Our report is here, madam.
It filed the report.
7.
Here is the report, madam. Item number 8.
8.
8. The বলছেন 7, 8, 9 all are same matter. My learned friend is now saying
One by one and take it up, please. Who is for the state in 7?
yes, I have.
7, Daulat Hussain.
Same order कौन state के report submission?
Yes, I appear for the state.
हाँ. You file a report. Huh?
Lordship.
Probably some of the candidates
Lordship.
who did not complete the breach course, they were granted A category scale of pay. At that point of time, there was no modality.
Lordship.
Now the petitioner says that the modality is in place. Whether that decision will apply in case of the petitioner. Now you have to complete the 6 months breach course as per Devesh Sharma and then approach the court for it. Huh? You cannot have that. One of the decisions of Justice Sinha says that you complete 6 months breach course.
Lordship.
You cannot force them to have DLED 2 years course. That is correct. Now here the modality is there. They have to take admission and comply the order of the Honorable Supreme Court. Thereafter they can claim. The others cannot, you cannot take the benefit of circumstances prevail at that point of time. So he will satisfy this court with regard to Waliur Rahman and you file your report. We'll examine that thing.
এই 30th January.
Same as 5, 8 টা ডাকো বেরে 8 এর রিপোর্ট আছে বলছো।
And I am applying for the 8 minute. Whether here is the report filed by the FBI.
The report affidavit of service filed on behalf of the petitioner is taken on record. The report filed by the district inspector of schools dated 5th.
একটা না দুজনে জেরক্স করে নিন। The petitioner passed the 6-month breach course in the year 2025 after the Supreme Court's order. Paragraph 2 and 3 and 4, my lord, specifically stated, my lord, in the report, my lord.
Not in service on that though. Subsequent clarification of business. Oh, it had a point. So what will be the course that petitioner will have to now?
But that I will take instructions. At present, I can,
because
the DPSC will.
This has been indicated that since 2025, 2023, there was a direction that in service has to complete 6 months breach course.
Before the judgment of the Supreme
before
Court.
that judgment.
After that judgment of the Supreme Court, nothing saying that.
You are given a copy?
Yes, I'm given a copy.
The report filed by this district inspector of school dated 5th December 2025 is taken on record. Mr. Anindu Biswas, learned advocate for the petitioner.
Number appearance
Seek accommodation is this matter on 30th. 30th.
I'm grateful.
ইমানি বাবু ওই প্রত্যেকটাতে বলবেন যে by the present writ petition they seek for A category.
I'm for the my lord counsel. Counsel.
9
9 also বলতে A category scale of pay, my lord.
same as 5 করে দিন নাকি state
But IFF for the state will not, in fact, will not kindly, this will be disposed of. I don't have the report as on date, Lordship, but whether that is required at all. If Lordship
Yeah.
dispose of the matter, directing the concerned authority, will not to consider if it applies to grant them. Finish it off. But in my humble submission, Lord, that shall be disposed of by making this observation. And my Lordship's observation will suffice in all the matters. They will have to take a decision if it applies. And to dispose of the matter. To avoid delay and all this, this is my humble submission. And they will have to take reasonable decision. If judgment is not applicable, worried amongst the matter, then obviously they will have to give the benefit.
I am on a different understanding that at that point of time the circumstances was different.
Lordship.
Now our representative is sent to the authority.
My lord.
The authority has admittedly granted 3,000 odd persons with A category scale of pay with BA degree without any qualification.
My lord.
The court has observed that there is no modality. That has gone with the mind of the court that since there is no modality, there is no scope for the petitioner to complete that. So you consider that. Now the modality is there.
Therefore,
Now what will be the fate of the petitioner bearing in mind the observation of the Supreme Court in Devesh Sharma?
What I am on is, my lord, since the modality was not there, now modality is here. Therefore, situation is changed. So this is absolutely within the domain of the authority to take a decision. Not decision. My lord, I should not say the rest of the portion. But I say, my lord, modality is there. Why it will not be applied? That is to that decision to begin with authority and matter can be disposed of. This observation could be made. Modality was not there. Now it is here.
Since the other matters I have not passed order, let this matter also come on 30th.
Lordship. I was
Another my lord, this
following my lord's observation. But I believe, my lord, to cut it short, the delay time and all this, my lord, this observation will suffice for everybody's interest.
On 30th, Mr. Naik.
Great.
30th.
Obviously.
No, only report দেবেন. You will not file any report?
No report I have not. No.
You will be filing on 30th?
I believe it will not.
It will not be required. No, file for that.
Yes.
Then my lord, I am appearing on behalf of the petition.
This is?
My lord, petitioner was appointed an assistant teacher. This matter, Bhaskar Basu is appearing on behalf of the council.
What is your prayer?
Prayer, petitioner made a representation for his joining. Petitioner was absent. There is a direction of honorable court upon the assistant, page 53. Lordship can come to. Starting from page 53. The petitioner has filed the present petition for direction upon the Assistant Secretary Elementary Education. Respect of petitioner representation dated as early as forwarded by the chairman. Page 52. Chairman is forwarded to the Assistant Secretary in respect of joining. Petitioner was absent. He was seriously ill. 2018, Chairman of District Primary School Council forwarded to the Assistant Secretary. With reference to the application dated 23rd July. For permission to join his school, he is informed that this officer has issued letter to the Assistant Secretary to the Government of West Bengal Elementary Education. On the basis of this memo, Honorable High Court directing the Assistant Secretary, last part of the order, I direct the Assistant Secretary, Government of West Bengal Elementary Education to consider and take a decision in respect of petitioner's pending application dated 23rd July, forwarded by the Chairman District Primary School Council Purulia within 8 weeks from the date of communication of this order. That the order was communicated and notice was of demand justice, my lord, page 56. That is pending before the Assistant Secretary, Elementary Education. No proceeding was drawn up.
How many days this is?
Yes, my lord.
1.5 years.
Yes, my lord. Thereafter, already there is a direction. Upon the Assistant Secretary order was communicated. Thereafter, my lord, no step have been taken by the Assistant Secretary. That was 7th May. We have the notice. That is only, my lord. I am
Assistant
directing that.
Secretary.
Already
Who is for the state?
State, my lord, earlier Biswabroto Basu Mullik was there. My lord, he is not in the panel because Goswami is appearing. And District Primary School Council.
Affidavit of service filed on behalf of the petition is taken on record by the present writ petition. The petitioner seeks for direction upon the respondents to consider.
Respondent number 2, my lord.
Respondent number 2.
Yes, Assistant Secretary. This is earlier direction.
To
Order passed by Honorable Justice Samapti Chatterjee.
take a decision on the basis of petitioner's pending application dated
23rd July 2018.
23rd July 2018 in terms of order passed by this Honorable Court on 28th March 2019 in WP 5836 within bracket W of 2019. Despite service, none appears on behalf of the state. Where is your affidavit of service?
Earlier occasion, my lord, I've already informed the notice. Notice is
It is not there.
No. Logically fix the matter next week. I will.
Learned advocate for the petitioner seeks accommodation to file affidavit of service. 30th.
And I am for the petitioner. And I think grade A PFSO instead of grade B. Well, petitioner got appointment on 17/2/2021. Thereafter, he joined on 18/2/2021. Well, thereafter, on 37/2024, valued Ahmad judgment was awarded in this court. For to give effect to your petitioner, petitioner made a representation on 3/4/2025.
Okay. Petitioner has joined on
18/2/2021.
18/2/2021.
My lord. Annexure P3.
Five মতো order করুন তো। Who is for the state? Give a notice to the learned advocate for the state.
My lord.
হ্যাঁ মিস্টার বোসের যে মামলাগুলো অর্ডার করলাম ওই অর্ডারটি করবেন 30 তারিখে আসবে only thing is learned advocate for the petitioner that will serve a notice upon the learned advocate for the
On 30th, my lord.
30th it should have.
I can deliver. Kindly come to page 18, my lord. Page 18 of this petition, my lord. I have coming, my lord, against the order of suspension passed by the chairman, Purva Pardhaman, my lord. My lord, I am the teacher of, my lord, assistant teacher of primary school since 2021.
Okay.
In 2024, my lord, uh, my lord, in 2024, my lord, a criminal case is filed by my wife against me, my lord, 498 and 498 325, and I was arrested, my lord, admittedly in 18/10/2024. 18/10/2024. My lord, page 18, my lord, and suspension on. Thereafter, my lord, in 30th 10/2024, my lord, I got bail, my lord, and thereafter, my lord, I resume my duty. I am doing, my lord, the works, my lord. Then suddenly, my lord, in 7th April 2024-25, my lord, nearly after 6 months, my lord, suddenly this suspension order was passed without intimating me, nothing, my lord. Through internet, I came to know, and thereafter, my lord, kindly see, my lord, this, my lord, the criminal case is not related to my service, my lord. Thereafter, my lord, with the retrospective effect, this, my lord, suspension order is given, my lord, without hearing me, and there are no disciplinary proceedings started against me. My lord, thereafter, my lord, page 19, my lord, I give a, my lord, detailed representation to the chairman, my lord. My lord, kindly see, my lord. There, my lord, stated everything, my lord. So I was doing my duties, my lord. There is no, my lord, problem regarding my service, my lord. This is not the case that this criminal case is, my lord, relating to my service or any moral turpitude, my lord. My lord, kindly see, my lord, that, my lord knows that criminal case, my lord, it will
But
only
then,
I have got the bail, my lord.
this-
It will, my lord, it will prolong, it will be going on, my lord. So, my lord, authority can, my lord, allow me to work, my lord. If I convicted, then, my lord, in on that score, my lord, there is judgment, my lord, may I place, my lord.
in custody is placed under suspension with effect from this. At that point of time, you are not suspended.
No, my lord.
So after 30th October, you joined the service.
Yes, my lord, I was working.
Without there being any order.
No.
Now 17th October with effect.
That suspension order also not, my lord, sub to me. Through internet, I came to know. Then, my lord, the headmaster didn't allow me to join. Allow me to, my lord, work. So, my lord, retrospective effect, my lord, this given.
Affidavit of state.
My lord, I thought, my lord, all are delivered. No, direct the chairman to withdraw this, my lord. If I am convicted, my lord, then, my lord, there is judgment, my lord. May I please?
State presence is necessary. Who has issued the suspension order?
My lord, chairman, my lord, Purva Pardhaman, my lord.
Chairman?
Page 18.
Oh, District Primary School Council.
Council, yes.
Purva Bardhaman.
Yes.
Who is for the council?
And I have, my lord, delivered, my lord.
Filed on behalf of, give it to the learned advocate for the.
Sir. It is delivered, my lord.
PI. Chairman District Government, delivered. 464.
What is suggesting, my lord, if my lord directed the chairman to consider the representation withdraw, my lord, that I have made, my lord, wrong back. If my lord can direct.
478.
Page 19, my lord.
By the present writ petition, affidavit of service filed on behalf of the petitioner is taken on record. By the present writ petition, the petitioner seeks for withdrawal / quashing of the order of suspension issued by respond number 4, Chairman District Primary School Council, Purbo Bardhaman, dated 7th April 2025, within bracket annexure P3. Mr. Wensu, learned advocate for the petitioner, submits that the a criminal case at the instance of the wife of the petitioner under section registered as Bar 1 PS case number 171 of 2024 dated 7th April 2024 under section 498A/325/307 of IPC read with section 3 and 4 of the Dowry Prohibition Act within bracket GR case number 834 of 2024 was initiated against the petitioner. The petitioner was arrested on 17th October 2024 and was released from jail custody on 30th October 2024. Thereafter, the petitioner resumed his. You have appeared?
Your Lordship, I usually appear for the DPSC Purva Bardhaman, but as of now, I do not have any instruction in respect.
Take the instruction, file a report.
Lordship.
Because here I find that at that point of time when he was in custody, he was not put under suspension.
Lordship.
He came out, he joined his services. Now after so many days, after 6 months, this suspension order has been. Whether how far it is sustainable or not, that is to be seen.
Lordship keeps it after a considerable period of time. I'll take instruction.
Resumed his duties in his place of posting. All on a sudden, on 7th April 2025, the impugned order has been passed by the chairman suspending the petitioner. Such suspension is not tenable in the eye of law. The petitioner has made a prayer for withdrawal of such suspension order. However, no steps on date 21st May 2025. However, no steps have been taken. Mr. Tanvir Jamal Ahmed, no?
Tanvir Jamil Mandal. I'll provide.
Tanvir Mandal, learned advocate appearing for DPSC Purva Bardhaman, seeks accommodation to filed report. Let such report be filed within a period of 1 week. Exception, if any, be filed.
Your Lordship, make it 2 weeks. Because in between there are 3-4 days of holidays in between, starting from tomorrow.
2 weeks, 1 week, 3 weeks per list.
Kindly fix a date, my lord.
On 30th, 3 weeks, 30th. 6th February. 6th.
Item 13, we appear for the petitioners. Well, the petitioners are teachers in the primary schools having completed their B.Ed course, my lord. Thereafter, the petitioner seeks before your lordships for A category scale of pay, pursuant to the orders passed by the Honorable Division Bench, and your lordships has also taken note of it. And your lordships has also passed an order, my lord.
30th.
Yes, 30th.
Affidavit of service?
No, I am bereft of the affidavit of service today, but they are appearing. Everybody is there. On the next day, I shall file my affidavit of service. And I undertake to file on the next day.
Same office with the undertaking to file the affidavit of service. State and DPSC?
State mallet.
You are for?
Board. Mr. Bosu Mollik is appearing, because there.
Similar 5-way order করবেন? Report from the state will be necessary. You will filing any report?
I think no.
No. And to change, just undertaking an union. Learned advocate for the petitioner undertakes to file the affidavit of service on the returnable date.
So very grateful.
30th.
The report shall be filed by the DPSC and the board.
I have directed the state to file a report. Since he is not interested to file a report, we'll take it up. The issues are same always.
Yes.
In this matter, I am for the district primary school council.
Matter Mr. Ujjwala is appearing for the petitioner. Now he is engaged in court of writ. I am praying for only short possible, your lords.
My lord, in this matter, this is a my lord the petitioner's elder sister. She was the, my lord, primary school teacher under Jhargram District Primary School Council. She died on, my lord,
It is an
17
elder sister.
elder sister. My lord, she appointed in the year, my lord, she joined on 18th April 2027. She, my lord, unfortunately died on, my lord, 17th September 2024. My lord, being the brother of the, my lord, deceased teacher, the petitioner made an application. He is claiming that he has made an application for compassionate appointment before the, my lord, sub-inspector of schools. And that letter also, my lord, is not reached, my lord, it was returned. As it is, my lord, appearing from the this, my lord, read petition. Now, my lord, I am appearing for the district primary school council under rule 20 of the recruitment rules 27 of the primary school. My lord, compassionate appointment is there for financial hardship for, my lord, since they are suffering if any financial hardship. But the application has to be made, and in the rules it is clearly, my lord, it is stated that in respect of, my lord, for the purpose of appointment of as a teacher, the requirements as mentioned in the, my lord, recruitment rules, that is necessary. But there is a provision for, my lord, group C in the secondary schools. But this petition is not, my lord, he has not made in accordance with rule. Within 2 years, he has the, my lord, he can make the, my lord, legal error, if any. Now, my lord, but his application, I have not, my lord.
Not possible, your lordship.
Then, my lord, fix in another day.
18, your lord, sorry.
This is the, my lord,
So let him
crux of
file
the
an
case.
application in the proper format.
That will be better.
Your lordship.
Leave may be granted to the legal heir to file an application before the competent authority in accordance with the rules. And this matter may be disposed of.
When did she pass away? On 13th
Passed
March
away,
2024.
my lord, yes.
2 years time.
My lord, 17th September, I have seen, my lord. That death certificate is there.
September.
বলো না ডেথ সার্টিফিকেটটা দেখে পড়াশোনা কিছু করে না 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 পড়াশোনা করে আসবে তো বাচ্চা ছেলে yes
Is at page number 19, your lordship. And the
এই বলুক
application.
না
19.
Yes, your lordship. And the petitioner made an application for the compassionate appointment, which was refused by the
Yes.
SI, your lordship.
SI is not the authority.
Kindly come to the page number 34, your lordship. And the DI also.
Tapoti Rana was the
Yes, teacher.
teacher is Tapoti
Yes.
Rana.
Tapoti Rana.
She died on 13th March 2024.
Yes. No, my lord, I have seen, my lord. Died, yes, 13 March. কবে মারা গেছে ডেথ সার্টিফিকেটটা থেকে বলো
Your lordship, 13 March 2024.
13th March 2024.
Yes, your
So as per rule, you have time.
I beg to appeal for the statement.
You filed an application in proper format before the appropriate
May
authority.
may I submit only 2 lines, your lordship? Kindly come to the page number 34, your lordship. And the petitioner made an application for the compassionate appointment to the DI and SI, your lordship. And
DI.
yes, your lordship.
authority না
33
DPSC district primary school council is the appointing authority, chairman of the district primary school council.
33 is
সেই জন্য বলছি
My lord,
and the
I
DI and
is
SI,
not
your
the
lordship, refused
my lord, one
refused the
objection.
application, your lordship.
brother is the
Apart from this, technical part, this brother is not coming under this scheme of compassionate.
Okay.
family
Family means
Where is
son.
that?
son or otherwise family to
There is this. He should come up with this right. Showing the
Which rule?
provision.
This rule is there, Mr. Chaudhary?
Your lordship, this issue is already has been decided by this honorable your court, lordship. This is the
elder brother
Transfer.
brother এর ক্ষেত্রে
but the
brother বলছে কি বলছে শোনো হুম স্পাউস ডটার সন ব্রাদার তো পড়ে না তাও বার করে দেখাতো
Reason order দিতে বল।
ওটা দিল হবে। তাও আমি বলেছি যদি তাও করে তাও করুক, কোর্টকে বলবে, কোর্টকে বলা আছে করো, মনে কিছু করো না, আমি একটু ভালো আছি তোমাদের।
Lordship, with your permission, may I submit one judgment order, your Lordship?
Yes, give.
The similar matter already has been decided, your Lordship.
ভালো ছেলে,
No,
গুড।
Lordship, in this matter, the petitioner's sister were
Wherein the senior circumstances,
Here only
the claims
the
independence
coordinate
is
bench has
simply done.
directed the authority to pass a reasoned decision. That is cannot
Petition disposal and chairman.
causing any right to be accrued.
But who will consider this one?
And the appropriate authorities would be the concerned district primary school council.
So where is this judgment, Durga Das?
yes, your Lordship, in this matter, your Lordship.
Durga Das is judgment. Where is that?
Pardon me, your Lordship, I have not taken that judgment with me, your Lordship. I have not taken that judgment with me, your Lordship. Kindly give me a time so that I can submit this.
But my lord, that's my lord district inspector of schools. My lord, he is not the authority to dispose of my lord this type of my lord regarding appointment in respect of compensation at ground, my lord. This is to be the appropriate authority is the chairman, who is the appointing authority. Yes, my lord. Therefore, he has to make an application in proper format if he has the eligibility criteria and also
If he is eligible. Brother is not a.
He is not eligible under the my lord.
Tell me the rule. Which rule?
May I just, my lord, may I just take out this headmaster manual? My lord, here my point was that he has not come up with that.
Volume J, sir.
Volume 1. Volume 1.
One. Give it one.
পেজ আছে না?
Lordship, my prayer is that your Lordship can give. I'm praying for Lordship, kindly fix a date, your Lordship.
No, no, 697, Geo 697 আর ফ্যামিলি তো ওখানে বলা আছে I thought that 697
500 ওটা ইয়েতে আছে, না না সেই আছে, সেটা আছে কম্পিটিশন গ্রাউন্ড, কিন্তু এটা হলো ফ্যামিলি পার্টি খায়। এই যে ফ্যামিলি সন
spouse, son and daughter.
এই যে দিয়ে দাও জোসেফকে, ছবিটি দিস পেজ নাম্বারটা মানে মেসি দিস বুঝতে পেরেছো? তোমার এলিজিবিলিটি ক্রাইটেরিয়া থাকতে হবে তো, আর কেউ নাই ভদ্রমহিলার হাজবেন্ড নাই, হাজবেন্ড এনওসি দিলে হবে না,
হাজবেন্ড নাই, সিঙ্গেল ছিল, আনম্যারিড।
এটা বুঝলাম, তো পেনশন পাচ্ছে না, ওর তো কিছু কোনো সিনিয়র, আরে বাবা সিনিয়রের কাজ আমরা করছি,
Only spouse, daughter,
তুমি ভালো করছো।
son is entitled.
In case of primary school, which rule is applicable?
Rule 20, competition ground of the recruitment rules 2016. 2016 recruitment rules. এই দেখ তারা এই এই যে yes rule 20
Who are the persons who can apply for compassionate appointment? Where is that rule? Under the primary. Huh?
ওইটা যেটা দিলে yes
2016.
2016
Dependence, definition of dependent.
No, 135 is compassionate appointment. That is correct. Who are the persons? He says rule 2016. Where is that? Then where is the category? Who are the persons who can apply for?
যেটা তুই দেখালি ওটা কই গেল বইটা দেন ওই তো ওইটার মধ্যে
In 2016 rule, the death is not rule 20.
তাহলে 2001 টা
Permanent incapacity. And I have, my lord,
2001
only lordship that GO 697,
এই তো
which
নাও এবার তুমি করো
this compassionate
he
appeal
will do
is being, my lord.
Where is the definition? Where is the definition of family?
Definition of family is not embodied in this.
Has to be.
এই ব্রাদার আছে কিনা বলো ব্রাদার অ্যাপ্লাই করেছে
Your Lordship will see that my prayer, my lord, for compassionate appointment to my lord was at the death of my brother. But since I am the most eligible person and there is no other else than me to look after my parents.
I have heard. I have heard.
Yes, I'm sorry.
Please wait. Listen, tell me.
And similar situation, Lord, has your lordship got the order of this honorable court on a similar situation where your sister has been favored with this?
No, only a reason order has been
May I
rejected to
complete
be.
my submission and thereafter?
Doesn't mandatory
May I complete my submission and thereafter, my lord?
No.
Only
Kindly cease.
they are under impression that he doesn't complete it.
Where is the definition of family?
In the compassionate appointment,
yes.
If I request your lordship to see the 2009 rules.
Yes. 697. 2009 rules 697 too.
Kindly cease
That
one.
I have allowed.
There is a proviso added. There is a proviso added that is Malot with regard to Balot of financial distress, how it is to be asserted.
Oh, I'm asking what is the definition of family? Who can apply?
2009 rules, if I request your lordship to see, my lord, directly the chapter 5. Chapter 5.
Shall you consider the proviso? Provide.
2009.
Yes, my lord. 2009 rules. It should be. I just take your lordship to
That book I have. That is the 2009 rule is there.
The rule calls West Bengal School Service Commission selection of persons and for appointment to the post of non-teaching staff rules 2009.
May I, once again, may I just take it out? Yeah.
বইটা বের করে দাও
My lord, is starting from 515 and relevant rule schedule 5.
My lord, I am just counting.
Under this rule, as for provision has been made for appointment on compassionate ground.
Now, my lord, has your lordship got the rule 2009?
Yes.
But if I request your lordship, see, my lord, page number, I'm sorry, rule chapter 4, which is, my lord, rule 20.
Yes.
And my lord, see, my lord,
How,
see,
how
my lord,
this rule will apply in case of primary education?
I tell your lordship that. My lord, rule 21, my lord, kindly sees.
Yeah. Now, where is the definition of family?
So, my lord, I request your lordship to see, my lord, annexure 5, which would be schedule 5. I'm sorry, my lord, which would be, my lord, schedule 5 of this particular rule.
531, that yellow, yes, this.
So, lordship has seen there, my lord, they refer to schedule 5. Now, lordship sees schedule 5.
Yes.
So, here, my lord, when the teacher or non-teaching staff dies, harness such and such, leaving a family which is in the opinion of the district inspector of the school in such extreme financial hardship that it fails to provide 2 square meals and other essential to the surviving members of the deceased teacher family, that is spouse, son and daughter of the deceased teacher or non-teaching staff family or staff's family who is possessing required educational qualification as laid down in schedule 1 of the post of clerk such and such, and unemployed and below is 18. So they were regarded to be the family and were included in this. So, my lord, what I beseech your lordship, my lord, that what I tried to impress upon your lordship on this point, that the whole object of this particular scheme, my lord, was to, my lord, giving a solace to the, my lord, dependent family members, specifically the family. So here, my lord, kindly appreciate that in this entire family, my lord, it is only the brother who is there. So, my lord, on to look after the parents. So, my lord, by saying this, my lord, I made this representation to the authorities. By them, that if they could have, my lord, considered my case, my lord, because time and again, my lord, this plight of this family, my lord, has been taken into consideration by this honorable court in various other judgments.
Awesome.
So this is why, my lord, I was relying upon the order of this honorable court. But you have seen that.
Yes. Affidavit of service filed on behalf of the petitioner is taken on record by the present writ petition. The petitioner seeks for direction upon the respondent authorities, particularly respondent number, district inspector of school number to the
May I pay for a leave, my lord, quantum application?
primary education Jhargram to accept the petitioner's application for compassionate appointment due to untimely death of his elder sister, who was a primary school teacher. The petitioner contends that his sister Tapoti Rana was a teacher, assistant teacher at Gopalpur Primary School under District Primary School Council, Paschim Medinipur. The petitioner's sister, elder sister, died in harness on 13th March 2024 due to metastatic carcinoma of the breast. Upon demise of the elder sister, the petitioner on 17 September 2024 made an application before the District Inspector of Schools as well as Sub-Inspector of Schools for his appointment on compassionate ground. And he also submitted supportive documents. The petitioner is a graduate and has completed bachelor's degree in commerce. This has been rejected or kept pending?
Kept pending.
The application. Oh. You say that it has been refused by the authority to accept the application.
It is that if your lordship sees my page number 33 once.
So they have not received the application.
They haven't even refused. So my application is not rejected. They straightway refused my prayer.
Application. Submitted an application, bolam na? Sent an application.
Refused to accept.
No, 17 September 2024, that was sent, not submitted. On 17 September 2024, made an application, sent an application.
Yes, yes.
The application returned undelivered with endorsement refused.
DI of schools.
There must be reason, kindly see page 35, that DI of school at Kodamtala. No specification which DI, whether primary, secondary, who will accept, whose case.
But,
it's very easy to.
Has got the instruction to that to say this.
No, kindly see the page 35.
It doesn't have the instruction or
this is the first time.
Nothing requires.
First time it is.
Page 35 DI of school, who's DI?
Since I served this writ petition, they should have the instruction.
Being agreed by such action of the respondent authorities, the petitioner has filed the present writ petition seeking for direction for acceptance of his application for compassionate appointment. Mr. So-and-so, learned advocate appearing for the petitioner.
1 second. My lord. DI has not been made parties. Page 2, kindly sees. Page 1 to 3. First state, then West Bengal Board, Secretary West Bengal Board, District Primary School Council,
thereafter
then District Jhargram, Secretary, Council, Sub-Inspector, Gopi Vallabh.
Find out this is not done now. You file an application without making a party against whom there is allegation that he is not accepting.
Yes.
After so much hearing, now it comes that the party has
But,
not been.
may I just request your lordship? Can I just pray for your lordship's leave and make the DI as a party?
On the
Because
prayer of
the-
on the prayer of learned advocate for the petitioner, leave is granted to implead District Inspector of School Primary
That will be
Education.
better.
So the allegation may not be, my lord. This allegation against the GI, I'm just disputing. Whether
No,
the
I-
application has, whether the application before the DI has at all been made not in proper format that has been taken by my learned senior friend from the appearing for the DPS. Now I say that, my lord, that it is not properly addressed. So how it can be alleged that one has refused?
My lord, application has to be made in the proper format before the competent authority. According to my submission, my lord, my humble submission before your lordship, the application
What
is
is
to
the
be
time-
made
what is
before the
time period
DPSC.
to file the application.
2 years from the date of
So
date.
you have
Yes,
time
2
to
years
file the
time is there.
application, file a comprehensive application
Yes,
before
আমি
the
তাই বলছি।
I'll do that.
without going into all these things that whether he has accepted, denied.
So grateful to you.
In the
You
proper
will- so
format,
grateful.
liberty is granted, let them decide.
Grateful.
First time I made this prayer before your lordship.
My lord, that in that case, what will be done, my lord? The provision says, in all respect, my lord, whether it is primary, secondary, or any other service, that 2 years is the mandatory. That cannot be relaxed.
That will
now,
not be relaxed.
If my learned friend, my lord, filed a comprehensive application,
That is
and if it is beyond 2 years,
How
2 years হচ্ছে না। এটা
13th March 2024 he has
আছে,
died.
আছে।
So he has 2
সময় আছে।
months
In
to
that
file
case,
application.
in that case, yes, 24, I have that.
That have seen.
Yes, yes. Therefore, I made the prayer, my lord.
Yes, it's always a pleasure, my lord, to appear on against them. Always.
No, no, no. I made the prayer before his lordship at first time. That this application is
Mr.
to be made
So-and-so,
for
learned
me.
advocate for the
যেহেতু তোমার
petitioner,
টাইম আছে।
submit
বলো,
that the
প্রথমেই
authority
বলেছি।
has refused to accept the application for appointment of the petitioner on compassionate ground. He seeks for appropriate direction so that the application of the petitioner at least can be accepted and considered by the authority concerned.
Grateful, man.
Mr. So-and-so, learned, you are for DPSC.
He is appear. I am for the
Learned
district
advocate.
primary school council.
Ranjan Kumar Saha, learned advocate.
My lord, not Kumar. I am only Ranjan Saha.
Ranjan Saha, learned advocate.
Then my
for
bill will be
DPSC. And Mr. So-and-so, learned advocate for the state, submit at the first instance that the brother is not the
Coming within the definition of minor.
coming is not a person included within the definition of family to seek for appointment on compassionate ground. Hence, the application, whether accepted or not, becomes irrelevant, since there is no right of the petitioner to seek for compassionate appointment. Upon considering the circumstances as has fallen before this court, it appears that the deceased teacher died on 13th March 2024. As per the rule, the application is to be filed within 2 years. Therefore, at this stage, without the application being filed in proper format, it would not be proper to decide the right of the parties at this stage. The authority is to decide on such aspect. Accordingly, since 2 years have not yet elapsed from the date of death of the deceased teacher, I am of the view that an opportunity be given to the petitioner to file his application in proper format before the appropriate authority. Who will be the appropriate authority?
My lord, according to my lord understanding, my lord, that chairman of the DPSC, District Primary School Council, being the appointing
Accordingly,
authority, he has to make the
petitioner is granted liberty to file appropriate application in proper format before chairman, district
Primary School Council, Jhargram.
respondent number,
So 4 and 5.
respondent number 4. 4. District Primary School Council, Jhargram, within a period of 2 weeks from date of this order, or 3 weeks, whatever. 2 months is there, so 3 weeks. Upon such application being filed, the chairman, respondent number, shall decide the same strictly in accordance with law.
Lordship.
With the aforesaid observation, the writ petition stands disposed of.
I just pray one thing, my lord. The decision of the DPSC, my lord, should be, my lord, done in a specific time frame. This is what I pray.
Within a period of 3 months from date of submission of the application.
Lordship.
Great. Right, the affidavit of service cannot be taken up.
For the affidavit of service file taken on record.
I'm for the petitioner, my lord, led by Mr. Firdaus Samim. He is engaged into another courtroom, my lord. For that reason, I'm praying for a not today.
I'm for the board, Lordship.
What is this case?
Lordship, this
Praying for a not today, my lord.
issue.
A category.
Lordship has dealt with, Lordship.
A category.
Not there, Lordship.
Okay.
My lord, I'm praying for a
Paying his time, Lordship.
Some matters will be coming up on 16th.
That is different. This is different, Lordship. Oh. It can be taken up. There is no urgency. Can you make it not this week, Lordship?
My lord, my senior is engaged in another courtroom, my lord. For that reason, I'm praying.
Next speaker.
And the sleep in the
Not to, can it be Friday week, Lordship? Because next week, Friday.
Where is he? On the prayer of the learned advocate for the petitioner, list this matter on 30th.
30th. Great.
30. Oh,
Yes.
I'm appealing for the state. On a very simple issue, my lord.
For the board, Lordship.
The petitioner joined service as trained teacher. Since the first day of his joining, he is getting A category salary. On 22nd December 2022, 28 November, kindly comes to page number 44 once. Terms of the order passed by this honorable court, a list was published in the website of the West Bengal Board of Primary Education. And that list breakup of all impaneled candidates were published. The relevant page is next one, minute, page 45.
It's a request your lordship. I have requested my friend is because Mr. Biswas is ill. He's seriously ill. My lord, he's not. He came yesterday, but again, it's wrong decision for him also. Kindly take it up on Wednesday. Without him, it's very difficult.
I have no objection, my lord.
Without him, very difficult.
For the joint prayer of the parties, list this matter on 14th, 15th. You have so many matters, and 15th also that matter is there yesterday.
15th, that matter I will assist your lordship. But
this is a very small issue, Lordship. That can be.
What happened to him? Yesterday he came, he moved.
Yes, for some time. For an hour or 2 years came. Lord, I'm told, my lord, something dysentery type is
okay.
He's already suffering from gastroenteritis, and then
okay, then on 15th, Mr. Sannal on 15th then.
16th.
15th, I have some difficulty.
16th.
16th, Lordship.
16th, it will not be possible because we have to leave for that opening.
Oh, then 14th, your lordship.
14th দেখো ভর্তি আছে তো নেক্সট উইকে করি তারপরের উইকে ওয়েডনেসডে কি তারিখ আছে
All of your losses will leave on 15th.
No, no, no. 21st, I'm keeping it.
No. All of your losses will leave on 15th.
Not on
For
15th.
inauguration.
He has difficulty on 15th. So he's asking for 16th. So
That's
16th in
16th
second half.
obvious.
That will. একটা ডেট বলো, যে ডেটে করা যাবে। 22nd
27th
22nd 22nd
22 তারিখ এই নিন
I am the petitioner, my lord. All the
বলেছি যে 2 weeks
respondents are appearing, my lord.
যাতে ফাঁকা থাকে সেরকম। বিশেষ করে মিসেলেনিয়াস
এই প্রথম দা 17
May I file my affidavit of service? My lord deems fit, may I place the matter.
সব 30 তারিখে যাবে। Yes.
The petitioner is a B.Ed qualified candidate, my lord. I have given all the educational certificates, my lord. The petitioner was appointed as a primary school teacher by way of an appointment letter dated 10th February 2017. That is at page 23 of the brief. I had joined on 14th February 2017. At that relevant point of time, for a primary school teacher, B.Ed was a valid training qualification. I'll just show that circular as well of the NCTE, my lord. That is at page 29.
should P10 there. Should P10.
This is a notification of 28 June 2018. My lord will see or, the words or, my lord, graduation with at least 50% marks and Bachelor of Education. So this was a valid qualification subject to me going for a bridge course. At that relevant point of time, bridge course was not even notified, but I had to participate in a bridge course which was notified later on. Now, my lord, in spite of me being a trained candidate, as on that date, it was a valid qualification, but thereafter, my lord, the Honorable Supreme Court had intervened. That the Honorable Order of Supreme Court is at page 30. I'll not trouble my lord with the entirety of the order. My lord will kindly come, it starts from page 30. My lord will kindly come to page 35. Page 34. May I read from page 34?
In service were granted liberty to complete that course.
My lord.
Bridge course.
Bridge course. Bridge course was not notified at that relevant point of time, and 1 year was given by the Honorable Supreme Court to start the bridge course. So, my lord, in my humble submission, I was recruited as a B.Ed candidate, as a trained candidate, not an untrained candidate, but the pay which was given to me was that of a untrained candidate, not a trained candidate. That is the grievance, my lord. I was given B category pay scale, which is meant for untrained candidate, and A category trained scale was reserved for persons having diploma in elementary education degree. In fact, some B.Ed candidates had been granted A category scale, and this was dealt with, my lord, by way of a order of a division bench of this honorable court, my lord. My lord will kindly come to page 40, my lord. This is an order passed by a division bench of this honorable court, and this says that when some candidates having B.Ed qualification were granted A category pay scale, the others have to be. But the judgment is very specific that it is limited to the petitioners in that petition. My lord, I'll just.
Where is that paragraph?
My lord will kindly come to page 43, paragraph 11. From paragraph 11 onwards. The position as it stands today is that
3446 candidates who stand on the same footing as that of the appellants are getting A category skill. A category is for trained candidates, despite having not undergone the 6 months bridge course, and therefore it is evident and apparent that the conduct of the authorities that the appellant standing on the same footing is inflicted with the act of discrimination offending Article 14 of the Constitution of India. Though the wise mind has awakened the situation after the direction passed by this court, yet it has not seen the ultimate destination, and it would be injustice to the appellants if they are denied similar treatment with those standing on the same footing. So the petitioners therein were specifically told that they have to be granted A category skill. I will kindly come to the next page. We found that the act of discrimination being patent on the basis of disclosures made in the report, the order impugned needs to be modified to the extent that the appellants shall be provided A category scale of pay in the same manner that of the 3446 candidates, and the authority shall take an independent decision in granting the said scale of pay from the date on which each of the appellants are entitled to. So a specific order, my lord. Similarly, there were other teachers who had approached this honorable court, and even in those petitions, my lord, the elementary education department was directed to take a view in that. Page 48 is that order.
May I assist your lordship? Lordship, the petitioner joined in the 2016 recruitment process as an untrained candidate. She joined in
Not
2017.
Candidate, I dispute.
Because B.Ed was not a qualification in the recruitment process of 2016. Notification by NCT came in the year 2018, which was shown by my learned friend. After that, we allowed in the recruitment process of 2020 B.Ed candidates. So B.Ed pass candidates, qualified candidates were officially allowed in the recruitment process of 2020 only. After that, Devesh Sharma came. In 2022, you also allowed, but Devesh Sharma swiped up all the B.Ed candidates, so they are not allowed. So only in the recruitment process of 2020, B.Ed qualified candidates were allowed in the recruitment process. In the 2016, the petitioner joined. Joining letter was 2017. 2016 recruitment process. He or she, I don't know. He joined as an untrained
qualification in 2016.
Only TET pass, state qualified.
TET qualified with B.Ed degree, not just.
B.Ed was not a valid qualification in the recruitment process of 2016. Only DLED was a valid qualification.
Even if.
So after the trained candidate was appointed, untrained were absorbed. As there was a dart of college, so it was allowed by the NCT that you can also absorb the untrained candidate. So we absorbed this candidate also. Admittedly, on 2016 recruitment process, he joined as an untrained candidate.
File your report.
But the only thing is that may I just point out this? If even assuming but not admitting that my learned friends' submissions are all correct, are all correct. If I did not have the qualification, I could not have been recruited at all.
The petitioner seeks for A category scale of pay. Mr. Sonok Bose, learned advocate for the petitioner, submits that the petitioner. You joined on which year? Petitioner
joined in the recruitment process of 2016. He joined in 2017.
10th February 2017 is the date. 10th February 2017.
Page 23.
Participated in the recruitment process of 2016 and joined in the year 2017.
Lordship.
Having B.Ed qualification. The petitioner has not been granted A category scale of pay, though similarly circumstanced candidates have been extended the benefit of A category scale of pay. He seeks that the petitioner be extended the similar benefit as of the other candidates. In support of his contention, he relies on the decision of Honorable Division Bench passed in Waliur Rahman and others versus State of West.
I shall be relying on paragraph 14 of the Waliur Rahman.
Which my learned friend has not placed. To come up with the report.
The only thing, if I may just one
2024. Mr. Kunshik Chaudhary, learned advocate appearing for the West Bengal Board of Primary Education submits that the petitioner joined as untrained candidate. Since
then why are you citing this?
at that point of time, the B.Ed qualification was not the appropriate qualification for recruitment to the post of primary teachers. Only TET qualification was necessary. He seeks to file a report. Let such report be filed by the state. Mr. Dole is appearing for.
I am appearing for the state.
Okay. What is your submission?
Submission is that we takes the submission of the DPSC because they are the appointing authority.
Okay. Mr. Chaudhary appearing for DPSC?
For DPSC and board both.
Both. তাহলে দুটোই করে দিন DPSC ঝোলটা ছেড়ে দিন 30th.
But the only thing I must point out, otherwise there maybe material suppression. If I should have assisted, my lord, I could not complete. The petitioner has in the meanwhile got a job in the upper primary category for which he has resigned from this job. What he wants is from the date of his appointment till the date of his resignation, the areas, if he was allowed to A category pay, he would have been given a better pay grade. He only wants the areas for that period, for his period of employment. Today he is not employed.
Petitioner has already resigned from the post of assistant teacher primary school and has joined in upper primary. However, he seeks A category scale of pay in order to get the arrears from the date of his joining till the date of his resignation. Mr. Sonak Ghosh's submission note. Mr. Chaudhary, you also examine this aspect also.
Lordship.
Make a submission.
Lordship, the report will be filed by the.
On 30th, this will appear.
The report, who will file the report, Lordship, directed?
DPSC chairman.
DPSC chairman.
Chairman, DPSC, respond number such and such.
Respond number.
Next.
Respond number. 7.
And, I'm the petitioner in this matter as well. And here the petitioner had participated in the 2009 recruitment process. He was initially not a successful candidate. He challenged the recruitment process, my lord. In that, there was a batch of matters in which the 2009 recruitment process was challenged, and an order was passed finally on 18th April 2024 by this honorable court, which is at page 25, my lord. I'll not trouble my lord for the entirety of the order. I'll just go to the relevant portion, page 27, paragraph 2 onwards. This court had, by an order dated such and such, has decided the terms and conditions mentioned, and all candidates who had filed writ petitions up to 31st January 2024 shall be eligible for appointment subject to production of their documents and participation in the selection process. So I had admittedly participated in the selection process. The writ petition, I had filed a writ petition. I have disclosed the case status as well. I have pleaded that I have filed the writ petition and have specifically disclosed the case.
January 2024.
At page 32 is the case status of the writ petition that I filed. The date of filing is on 3rd August 2023. So I qualified. So I was given an appointment letter.
What is your problem?
The thing is that at that relevant point of time, I did not have the 2 years DLED course for which I had to do a bridge course. Now, my lord, will kindly come to page 33. This I have been told that I am not eligible for that course since I joined in accordance with that order, although it was a recruitment process of 2009, but I joined much later because of the illegalities of the selection commission. Public notice for 6 months bridge course. The Honorable Supreme Court issued the following directions by it, order dated such and such. As it appears, the notification quotes the Supreme Court order. As it appears that a large number of candidates with B.Ed degree had already been appointed on the basis of eligibility criteria specified by educational authorities. I was not recruited at that relevant point of time, but I ought to have been recruited in the 2009 process, which was corrected by this Honorable Court. We do not think it equitable to effect their removal. We accordingly hold that the judgment delivered by this bench on 11th August 2023 shall have prospective operation, which this says that the B.Ed qualification and but for those candidates who were appointed without any qualification on conditions imposed by any court of law to the effect that their appointment would be subject to final outcome of their case, which might have been instituted by them. And such candidates were in regular employment without any disqualification and were appointed in pursuance to a notice of advertisement where B.Ed was stipulated to be valid qualification. Services of only such candidates shall not be disturbed because of this judgment. We make it clear that the benefit is only for the candidates who were appointed prior to the date of the judgment. The judgment was delivered, that is on 11th August 2023. Yes, 11th August 2023, I was not recruited. But this is a 2009 recruitment process. I ought to have been recruited. I was not recruited due to the illegalities of the selection commission. This Honorable Court corrected that. And pursuant to order of this Honorable Court, which came later, I was recruited. But now, since my appointment letter is of a date subsequent to 11th August 2023, the selection committee says, I will not allow you to even participate in the bridge courts. I will not allow anything. That is why this writ petition, my prayers are at page 20 onwards are my prayers. Prayer B is to allow me to participate in the bridge courts. Prayer C is to treat me as a trained candidate thereafter.
Lordship, may I cut short the matter, Lordship, because NIOS and NCT are the answering respondent. They are conducting the 6 months bridge course, so their presence is required. NCT is a party, but NIOS is not a party respondent to the
NCT. I have made them a party.
NCT is a party, but NIOS is not a party. Their presence is required because they are conducting the course.
But for 2009, has they published any notification?
Lordship, 2009, there are several orders. The candidates are doing the courses in other districts also. Mr. Prasad can enlighten that.
That other candidates are doing. Let me note out.
Only one thing, because there is a cut-off date, Honorable Supreme Court, and the NIOS notification, NCT notification that my learned friend has, there is a cut-off date. Within that period, who is the in service, they are allowed to take admission in the 6 months bridge course. Now, there is a dispute with regard to that. There are writ petition has been filed before this, or those who are appointed in 2025, 2009 recruitment, what will be their fate? There is a difference of opinion in between two judges. It was sent to the division bench. Division bench has allowed those who has recruited 2025 provisionally admission in 6 months bridge course. It is the order. এই যেটা ইয়ে ছিল
ওই তো কদিন আগে ওকে দিয়ে দাও না নাম্বারটা।
They have allowed provisionally to take admission in 6 months bridge course. subject to the result of the.
But if the similar benefits can be extended to me.
Give a notice. Affidavit of service.
Affidavit of service merit maybe.
While the petition is taken on record on the right. टीचर बना টাকা দিয়ে প্রচন্ড ক্যাজুয়াল ইজিলি পেয়ে যাচ্ছে বলুন on the clear learned advocate for the petitioner leave is granted to who has issued the notification, which authority has NIOS?
My lord, that notification on the one.
NCT very less.
No, page 34 is not NIOS.
My lord, this is NCT. And page 34, but the condition has been prescribed. My lord, who are eligible to take admission.
Continuation.
NCT is a party, man.
NCT party.
Served, man. NCT is a party, they have been served.
After the cutoff, my lord, they have been
the other notification, because in terms of the notification at page 33, the NIOS is supposed to issue a notification that in such and such period the candidate such to take admission in bridge course. Where is that?
My lord, it is extended up to 19th of January 2026, this month.
So that has not been annexed to the writ petition.
Not has.
And the order records that is conducted by the NIOS.
Yes, NIOS. Base course.
And, I'll bring the notification. I did not know. I will search and
On the prior learned advocate for the leave is granted to implead National Institute of Open Schooling within bracket in short NIOS as a party respondent. Added respondent number 11. By the present writ petition, the petitioner seeks for granting him permission to take admission in 6 months breach course in terms of public notification dated 7th April 2025 issued by the National Council for Teacher Education within bracket in short NCTE. Learned advocate for the petitioner is directed to serve notice intimating the next date of hearing to learned advocate for NCTE as well as NIOS. Serve upon the learned advocate.
Right.
Who appears for NIOS? Mr. Banerjee appears.
Yes, Mr. Banerjee. NCT, Mrs.
Mr. Shiv Shankar Banerjee appeared in other matters. Whether he has been assigned this matter, I don't know. But he appeared for NIOS in other matters. And for NCT, sir.
I will.
Item 17.
List on date bolo. When is the last day? 19 January.
19 January.
January তে তো আছে 19 তাহলে কি করে হবে 16th নয় 15th দাও on 15th.
Fine.
Lordship, next item can be resolved, Lordship, because the petitioner had already given the
19.
19.
Learned advocate for the petitioner. Affidavit of service, madam. Filed by the petitioner is taken on record. Learned advocate for the petitioner. Submit that the grievance of the petitioner has already been resolved and addressed. Certificate has been issued.
But if they have certificate was misplaced, then petitioner has got certificate. So
Oh, the she informs the court that the misplaced certificate, she informs, ওখানে বাইতে করছিলাম না? হ্যাঁ, address. Now ওটা কেটে দিন. Informs the court that by the present writ petition, the petitioner sought direction upon the respondent authorities to issue/provide teachers eligibility test within bracket TET 2017 pass certificate. However, during the pendency of the writ petition, the petitioner got the misplaced certificate, and as such, the present writ petition has become infructuous. In view of the above submissions, the writ petition stands dismissed as infructuous.
grateful.
I'm for the state law.
Yes, give your name. Thank you, sir.
Lord, I am appearing for the petitioners, Lord. In this case, Lord, this is with regard to, Lord, appointment to the post of primary teacher, Lord, under Purulia Primary School Council for the process of 2010 recruitment process. Now, Lord, before going to the petition, my Lord, may I tell the brief fact of the case. The petitioner's name were sponsored by the local employment exchanges. And Lord, after sponsoring the name, the chairman of the council, my Lord, prepared a list of eligible candidates, my Lord, in pursuance of the, my Lord, academic qualification and marks obtained by the petitioner.
No, just a minute.
So, my Lord,
Who is
the
appealing
list,
for DPSC Purulia?
Purulia Primary School Council.
Yes.
Bhaskar Prasad Boishu only appeal.
You are for whom?
I am for state lordship.
Oh. Yes.
Now, my Lord, the
DPSC is the answer.
council was informed, my Lord, and the learned lawyer was appearing. He was also informed. Personally, I talked to him. Lord, after Bhaskar Boishu, after, my Lord, preparing the list, my Lord, those who have, my Lord, got less mark than the petitioners, my Lord, they were, my Lord, listed, eliminating your petitioner's name. Lord, that is the sum and substance of the case, my Lord. Against that illegality, my Lord, your petitioners, my Lord, moved this Honorable High Court, my Lord, in the red jurisdiction. The Honorable Justice Nadera Patheria, my Lord, as his Lordship then was, my Lord, take up the matter, my Lord, and after contested hearing, set aside the entire, my Lord, the selection and entire, my Lord, the list. And to take direction, my Lord, to take fresh list for that. Lord, your Lordship now come to the petition, my Lord. Page 131. That is the order of Honorable Justice Nadera Patheria. And my Lord, the operative part of the order is 132. Operative part is, my Lord,
yes,
132. And my Lord, after that order, my Lord, the chairman of the council made the same illegality and same mistake, same error. Your Lordship kindly come to page 133. Next page. The order passed by the council.
So this order dated 14th February 2012 has not cancelled the panel. It has directed for reconsideration of your representation, which you had earlier rejected.
Yes. So, my Lord, the same mistake has been committed or the illegality has been committed, saying that the name of the Madhusudan Chatterjee has been dropped. So, Madhusudan Chatterjee is not the factor. There are so many Madhusudan Chatterjees in the list. Those who have got, my Lord, less mark than your petitioners. And, my Lord, the next one is the China Mondal. We have given some example because we have not, Lord, got the records of all the candidates. It is with the council, chairman of the council. So, my Lord, the next man, China Mondal, the chairman asked to submit the record. Where from we will get the record, my Lord? Where from we will get the marks? It is with the chairman of the council. because his name has been sponsored by the council, in the council by the exchange. So, my lord, we have given the example, a substantial number of candidates who has got less mark than your petitioners, they were, my lord, enlisted and they were allowed to, my lord, participate in the selection test. So, my lord, that is the illegality. Here, my lord, after that, my lord, we have challenged that order in this writ petition, the instant writ petition. Now, my lord, after hearing, my lord, the coordinate bench of this honorable court, my lord, directed to file my lord, the affidavit, my lord, report in the form of affidavit. They have filed it. My lord, we have also filed the affidavit exception, saying, my lord, our submissions therein. So, my lord, I am suggesting before your lordship, my lord, it will be a workable order if I suggest before your lordship, if you're subject to your lordship's approval, my lord. My lord, your lordships kindly direct the chairman of the council, my lord, took a decision for participation in the selection test on a, my lord, fixing date of, my lord, selection. After considering the case of the petitioner and after giving opportunity to the petitioners, my lord, pass an order, my lord, within 4 weeks, and thereafter the order may be communicated to the petitioner. It is my humble suggestion or submission before your lordships. If your lordships thinks fit, then your lordships can pass that order, giving, my lord, the entire
Passing any
responsibility
direction,
to the
the
chairman.
order passed up pursuant to the order passed by the court is to be examined whether it is correct or not.
Mr. Bhaskar Prasad Vaishya, he went to Dr. Shima due to his illness. Just I have been informed by his clerk, kindly place the matter in the next week. He even not in a position to join it, on that.
এটা কি আমাদের মিসেলেনিয়াসে আছে? হ্যাঁ, হিয়ারিং এর আমরা যে কোনো দিন নিতে পারি তো। Mr. When so, learned advocate for the petitioner submits that the grievance of the petitioner is that precise grievance of the petitioner is that the candidates having lower marks than the petitioner has been allowed to participate in the selection process. Stop. Earlier, in an earlier round of litigation, this court in WP number 11002 within bracket W of 2011 passed order directing respondent chairman district primary school council Purulia to consider the representation of the petitioner afresh dated 9th December 2009. এই ডেটটা যেটা পাস হয়েছে ডেট অফ অর্ডার হচ্ছে 14th February 2012. Sir, what is the date of the representation in the year 2009 which was directed by the court to be decided by the chairman?
No, এটা রিপ্রেজেন্টেশনটা আছে at present No, my lord, not with this writ petition, because it is in the earlier writ petition, my lord, the representation.
No, the earlier writ petition in page 132 records that this honorable will not prevent the chairman from considering the petition's representation
Yes,
dated
my lord.
9th December 2009. 9th December.
Yes, so my lord, again,
bolo.
the impugn order, my lord, the passed by the council, that has been on.
Though the representation was considered, but the same has not been done taking into consideration the contention raised by the petitioner. The present writ petition has been filed challenging the order of the chairman dated 15th May 2012. Sorry, 2012. 15th May 2012.
My lord, your
Mr.
lordship
Arindam Chattopadhyay, yes, Mr. Arindam Chattopadhyay, learned advocate, informs the court that Mr. Bhaskar Prasad Boisho, learned advocate for DPSC Purulia, has left the court for visiting the doctor's chamber.
Today it could not come.
Informs the court that Mr. Boisho, due to his illness, has not come to court today. In view of the hearing, a date bolun na. Kuri tarikhe to hearing it. Sure. 20th January.
But at 2 p.m., my lord, kindly accommodate me.
Yes, 2 p.m. দুটোর সময় দেখবো নাকি একটু পরে আড়াইটে তিনটে 3 p.m.
3 p.m. I'm grateful to your lordship. নাম দুটো দিয়ে দাও দিয়ে দিয়েছো
Number 427.
Bholanath Das, my lord. I was so hoping that it's not a 3:30. I could have just finished off. Unfortunately, we've just been notified it's a 3:30. But I will still try and finish.
You will take entire period today. Lordship, I am appearing for spot number 1 to 6. Lordship, my junior colleague will be here. I have to leave, Lordship, for another matter. Let him continue, Lordship. He will be.
Nobody has to argue now. Only I have to give a reply to both my friend and also the
No,
learned
he
advocate.
is to.
You're there.
Yes, they're there.
Lordship, he will be citing some judgments. Lordship,
I'm not
kindly.
citing, I'm distinguish. I'll be today, my lord. I'll be relying upon their documents that they have filed, the new documents they have filed.
So if he concludes today, then we do not have to say anything because your Lordship has heard us at length.
You have filed your notes.
Lordship, we have not filed our notes. Kindly allow them us file our notes. We have only filed our citations.
Yes, my lord.
And give a short notes, points.
Yes.
Only if you can complete today, then only.
My lord, I will complete today, but there are some judgments that they have cited. Those my lord, distinguishing those judgments will take some time. I would have finished today, my lord, but since it's a 3:30, on the next day I'll only distinguish their judgments for about 20-25 minutes and close it. But today, on my lord, I'll complete my arguments on their points.
Lordship. Lordship, with your Lordship, leave kindly. My junior colleague will be there.
Other matters, yes.
Lord. May I, my lord, just give your lordship, my lord, a brief recap because it's been a long time, my lord, since the matter took place. My lord, there was a person who was engaged to assist me in the petrol pump. I was running this petrol pump from 2007. From 2007 till 2014, I ran the petrol pump. In 2014, and as part of my written note, I will give a tabular list of dates also. It's in 2014 that I engaged this person to assist me in running of the petrol pump. Then, my lord, it so happened that this person who was assisting me, my lord, in running the petrol pump, he was, my lord, embroiled in some ED, some case. So, my lord, he got embroiled there, he was arrested. That is when, my lord, I directed him not to come to the petrol pump any further. And the matter was put to rest there. Now, my lord, it's this disgruntled person's case, and he has filed a suit. It's his case that he lent me money for, my lord, buying a plot of land and beside the petrol pump. And also for my mother's treatment, etc. And he has filed a money recovery suit. And I have shown your lordship, my lord, that this is a money recovery suit. Then this gentleman sets up his daughter, and no relief in the suit. Nothing happens in the suit insofar as him suing me is concerned. His daughter makes a complaint, my lord. This complaint was, my lord, made in 2015. In 2015, the daughter makes a complaint to the oil company saying that I have violated my terms with the oil company by entering into a partnership with her father. And therefore, I have breached the agreement, and therefore my agreement should be, with the oil company should be terminated. So naturally, my lord, if somebody is against me, he would want to harm me in every way possible. Otherwise, how is he concerned at all with what is going on between me and the oil company? The entire endeavor of this complaint was to cause me damage. Then, my lord, the oil company called me. I went to the oil company. I submitted whatever documents they wanted, everything, and the matter was put to rest. Done and dusted, I continued to run the pump like I always did since 2007. In 2016, my lord, the matter was put to rest in the month of January. Towards the end of 2018, almost 2.5, 3 years, my lord, later, suddenly a show cause notice is served upon me. So one of the arguments that I've taken is that this is, my lord, hit by acquiescence. When you have allowed me to run for so long, you suddenly can't wake up from your slumber, and for this I have cited a decision, which I'll, my lord, refer to. Then, my lord, we put a reply to the show cause notice, explained everything, how this person is prejudiced against me, how he has set up his daughter, how it is only his own case of money recovery from me, not settlement of accounts of any partnership business. He has pleaded that the loan was given which has not been repaid. And, my lord, we my lord, justify, my lord, facts on the show cause notice. After, my lord, all of that was done, my lord, again, my lord, the oil company, my lord, sleeps for 3 years. And in 2020, my lord, 2021, they again, my lord, called me for an inquiry. So it's a 3-year, my lord, ritual, like a pilgrimage, that every 3 years they wake up from somewhere and call me. So again I go. There is a sham of an inquiry held for a few minutes. And the irony is that the person upon whose complaint I was being prosecuted was not even part of the inquiry. In fact, he was not even ever called for the inquiry. So in the absence of the complainant, without any questions put to the complainant by anybody, and inquiry is concluded within a matter of 20-30 minutes, and thereafter a termination order is passed terminating my dealership. Further irony is that the officer who was prosecuting me is the one who has, my lord, solely himself signed the termination terminating me. And the termination order doesn't even, my lord, whisper either to the authority before whom the hearing was held or to the head of the state, who is actually the authority authorized to, my lord, terminate someone's dealership under the guidelines. My lord, in these facts, my lord, I came before your lordship. Your lordship, my lord, initially on day one, my lord, affidavits were given direction, and since the writ was to be heard expeditiously, there was no interim order, my lord, passed. My lord, in the meantime, affidavits were complete, matter was ready for hearing. When the matter was, my lord, ready for hearing, the oil company took a complete U-turn. The U-turn is that in their affidavit in opposition, they have in a way admitted that this termination order was passed by the officer who was prosecuting. But during final arguments, they took a U-turn and they sought leave to bring on record additional documents, etc. So, seeing this conduct, that the matter is ready for hearing and you're derailing it further, very well, the honorable judge took a view that I'm giving you this liberty, you bring on record what you have to, but I'm going to at least grant an interim order. And an interim order was, my lord, granted by the learned single judge, my lord, not only, my lord, restraining them from taking any coercive steps, but to resume oil supply. My lord, this interim order was then, my lord, challenged before the honorable division bench. The division bench, my lord, was of the view that once a matter is ready for final hearing, it ought to be heard finally, and that an interim order could not be passed at a stage when affidavits have been exchanged. Matter should have been heard finally, because an interim order initially on day one was not given and affidavits were directed. So the matter should have been disposed of finally. So in a way implying that a interim order again would somewhat be hit by res judicata on those lines. My lord, that order of the division bench was taken to the Supreme Court. The Honorable Supreme Court directed status quo to be maintained, because as a consequence of termination, resumption of oil supply is one thing, but there are severe other aspects. For example, they could have come and broken down all my infrastructure, taken the reservoir, the equipment, etc. Plus, they could have also allotted the quota for that neighborhood to another petrol pump, another person. So this would have caused me irreparable loss. Supreme Court directed status quo. Do not take any coercive steps and let the writ petition be heard out. That is when, my lord, we came back to your lordship. My lord, the matter was heard. My lord, I have placed my arguments. Now, my lord, in the process of, my lord, arguing, my lord, I have cited decisions on essentially 6 points. I'll just give a short recap, my lord. The first, my lord, point is that the authority who hears a case must be the one who makes a decision. It cannot be that one person is hearing and then the other person makes a decision. And if the other person is making a decision, then I should also have an audience before that other person. Whoever is consciously deciding on something against me must hear me and decide. Basic principles of natural justice. My lord, the second, these are, my lord, the 3 decisions I have cited. My lord, I believe, my lord, your lordship has the judgments. Then the second, my lord, decision that I cited was on the second proposition was that an order speaks for itself and it cannot be supplemented by reasons in affidavit. So if there is an order passed by a government authority or a government company which is being challenged before a court, the challenge must be based on the 4 corners of the order, and the government cannot supplement and add to its order by way of affidavits.
1978.
Yes, because If that is permitted, then any person who has passed an order, any bureaucrat who has passed an order, can perhaps be dishonest and subsequently come up with 100 other things subsequently, which perhaps may not have even been in existence at the time of passing of that order. Creation of any kind of documents, all it takes is a signature and a backdate. So these things have consciously been dealt with by the Supreme Court, that this is the reason why an order should be judged by its within its four corners and not being supplemented by affidavits. Then, my lord, the third line of decisions, my lord, that I cited were decisions on what are the principles of natural justice. These must, my lord, following natural justice must include clearly informing the charges that are leveled, the examination of the witnesses in the
1963.
Yes, these are, my lord, 1963 and 1972. And of course, they rely upon a privy council also, my lord.
Yes.
Clearly informing of the charges leveled, the witnesses, my lord, being examined in the presence of the concerned person who's being against whom coercive action is being taken, who's being victimized, and fair opportunity to cross-examine the witness, and an opportunity to examine witnesses in his own defense. And, my lord, there must be a reasoned order. In this case, none of these things have been done.
Witness is not examined.
My lord, witness never even came. The person on whose complaint they have taken action against me never even, my lord, participated in the inquiry. And he has argued that how could I participate in the inquiry? The oil company never called me. So why he was not there is inconsequential. If the oil company proceeds against me, the least they could have done is ensure that the person who's making a complaint was there present to make his stance and make himself available for questioning.
As per you, what was the materials on the basis of which such order has been passed? Is it a baseless order without any materials being gone into?
Baseless order without any valid materials being gone into, and the materials also which have been gone into have not been proved. In fact, it is purely hearsay, because these materials have been given by the daughter of an alleged of another person who claims to have entered into a partnership with me, and he himself has sued me only for recovery of loan. And neither the person nor the daughter making a hearsay complaint was present in the inquiry. So not only is the complaint hearsay, but neither the original complainant.
No, the daughter is the complainant.
No, daughter is the complainant, but she is not speaking about what she has done. In the complaint, she says, my father did this, my father did that.
The father is the original person who assisted this petitioner.
Exactly. So the daughter's complaint by itself is a hearsay complaint. If I say, my lord, that my junior has spoken ill about my solicitor, then that is not evidence of the fact that my junior has spoken ill about my solicitor. That is evidence of the fact that he has told me that he has spoken ill about the solicitor, unless I have seen it happen in my presence. So in the complaint, I'll show the lordship the complaint again. It's a completely hearsay complaint. She says, my father did this, my father did that. How was she involved herself? No. But let alone, my lord, even she was not called for the inquiry.
Her source of knowledge has not been disclosed.
So the complaint is made by the lady saying that my father did this, my father did that. Neither the father who actually was said to be involved or the lady who was giving hearsay information, neither of them were there. So I don't even have to go into whether it's hearsay or not, because neither of them were there. And my lord, and then, my lord, principles of natural justice apply to administrative proceedings as they do to judicial proceedings. This also, my lord, I have cited, my lord, two landmark decisions, 69 and 1978 Supreme Court, where, my lord, the courts long ago only have, my lord, held that same principles will apply to judicial and administrative proceedings. You cannot do away with the principles of natural justice. And then, my lord, the fifth point, my lord, on which decisions were cited were marketing discipline guidelines. that, my lord, these are guidelines. Now, my lord, what happens is the agreements which are signed with these petroleum companies, these agreements state that, okay, if something goes wrong, termination may be done, etc. But how will the termination be done? What will the factors be taken into consideration before deciding on termination? Who will be the authority who will terminate? What process will that authority follow in terminating? All these aspects are not mentioned in these contracts which are signed with the different, my lord, dealers.
Yes.
Because, my lord, the contracts also differ from case to case. There are contracts where the petrol company itself will own the land or will be the lessee of the land, and they will set up the entire infrastructure, and the dealer is just required, my lord, to run and, my lord, oversee the operations. There perhaps termination is not as big a deal, because the dealer just loses the opportunity of running the petrol pump. But if, like in my case, the land is mine, the entire investment is mine, the infrastructure which has been created has been done at my cost, and based on this I'm given a long term agreement, and then if there is a termination, my lord, I'm destroyed. So each dealers also, my lord, differ based on the nature of investment, my lord, involved in the project. Sometimes the oil company owns the entire pump and the dealer only runs it. Sometimes the dealer is the owner of the pump and the oil company is a mere supplier of oil. Like, my lord, in the instant case, this is, my lord, important for that argument that I can claim damages. So, my lord, which is why the marketing discipline guidelines, my lord, were introduced, which laid down who can terminate, when can termination be done, when not, what are the factors to be considered, what is the procedure. And, my lord, decisions were cited, my lord, 4 decisions were cited, 3 of the Supreme Court and 1 of the Delhi High Court, to show that these are binding and that courts will intervene if they feel that the termination is illegal. And all these decisions are, my lord, contrary to that sole one decision where my learned friend was saying that the remedy is in damages. And I will distinguish that. And, my lord, the last, my lord, decision which I cited was, my lord, actually not, my lord, our original thinking, but, my lord, something which fell from your lordship. Because in this matter, my lord, constantly there is correspondence of the oil company telling me that you apologize and we will withdraw the charges. You apologize, we will withdraw the charges. And I have continuously gone on saying, I will not make an apology because I have not done anything wrong. And until one day prior to the inquiry also, they were insisting that I apologize and they will withdraw everything against me. Yes. So I have actually been prosecuted and punished not for a wrong that I have committed, but for having refused to apologize for an alleged wrong which I have been accused of committing.
Yes.
This is, my lord, where the ego battle comes in. I asked my client, why didn't you make an apology? You could have just apologized and finish. He said, no, why should I? When I have not done something wrong. And another point he has, my lord, that the gentleman whose daughter made the complaint, we never entered into any kind of business association with him. And today, if I admit to having done anything with that person of such a tainted reputation, it will give me a bad name in the market. So why should I unnecessarily make an apology and admit something which I haven't done, which will otherwise prejudice me in general? So, my lord, your lordship then asked that isn't this acquiescence? That 20 alleged wrong committed in 2014, complaint filed in 2015, and the termination happens in 2021. If this was a suit, it would have been barred by limitation. So, what is your say on this? So, Mr. Banerjee that day was leading me in the matter, my lord, and he had said that this is acquiescence. That by acquiescence, you have allowed, the oil company has constantly known what has happened. They have been satisfied with my documents. They have allowed me to run the petrol pump. They have supplied oil every day until 2021. Then why in 2021 will they take action against me over something which allegedly happened in 2014 after 7 years? So, my lord, I had cited, my lord, in fact, a decision, my lord, of the Allahabad High Court in a petroleum case itself. Recent decision. The reason I cited that because, my lord, facts were very similar. Petroleum, my lord, company, oil company's case, and it was, my lord, held that there is acquiescence. If you sit tight for a long time and continue to do business, you get a person used to operating in a particular manner. Then you can't victimize him.
This is 2023 SCC.
2023 SCC Online, Allahabad 2590, paragraph 37. Your Lordship, my lord, recalls everything.
Yes.
So, my lord, these were the decisions, my lord, that we cited.
Now, another was 2012, volume 2, SCC, page 1.
22, yes. This was, my lord, that the marketing discipline guidelines, cases where termination of dealership was quashed, where they say that the only remedy is damages. The Supreme Court in the writ jurisdiction has approved quashing of dealership. It's discretionary, my lord. I must say that when, my lord, something of this nature happens, your lordship as the writ court, my lord, has a discretion whether to quash it or whether, my lord, to give the party liberty to file for it. Here, my lord, I am only on, my lord, the legality of the action against me. All these months, years, my lord, that I have lost business, I have suffered. I'm not claiming even 1 rupee before your lordship. Your lordship cannot, of course, adjudicate my claim, my lord, on damages as to how much money I would have made if my petrol pump was running, etc. I'm only on the legality of the action. Could the action have been taken? And could it also have been, if taken, could it have been taken in the manner in which it has been taken? I'm only on these 2 points. Because, my lord, there is, my lord, a constitutional issue involved. Termination restrains me from doing business for a period of certain number of years, my lord, with government companies. I cannot be doing any business within that town. There are other civil consequences of the contract which hit me. So it is not a simplicity case that, okay, we are not happy with your services anymore, so we are doing away with you. No, it is a penal action. It is tarnishing my name, and the termination in this case is punitive, being on disciplinary grounds. That, my lord, affects my ability to do various kinds of businesses with various government companies. So it's purely a it's squarely, my lord, covered under, my lord, part 3 of the Constitution. Because I'm not claiming damage, my lord, damages I'll have to go before a forum if I have to claim damages. Here, whether what they did was right, even if your lordship goes ahead to declare that this action is wrong, your lordship may do 2 things. Your lordship may declare that this action is wrong. Your lordship may declare that this action is wrong and also direct them to resume business with me.
Yes.
So even if your lordship gives me part 1, a lot of my troubles, my lord, will stand resolved. But of course, my prayer will be full, my lord, for it to be declared, the action to be declared to be illegal, and for the dealership to resume. And the third prayer, of course, which I can't make here, is what about the losses that I have suffered because of this illegal action? That, your lordship, my lord, I'm conceding. My lord, a writ court may, my lord, in an exceptional case, grant some, my lord, amount of compensation to a victim. But the kind of damages that my client has, my lord, the figures that he has given me, my lord, I don't think a writ judge, my lord, can adjudicate those. So I'm not pressing those. And it's not even prayed for in the writ petition, my lord. Now, my lord, kindly consider, my lord, the extra documents, my lord, that they have now filed. But, my lord, before this, my lord, for a moment, my lord, kindly, my lord, take the writ petition. Kindly, my lord, see the order passed at page 116. Is your lordship there?
Yes.
Yes, my lord, kindly now, my lord, consider page 116. This is, my lord, the order. My lord, it's, my lord, a direct communication to me, to Bholanath Das, and then you are operating so and so. So there's a communication being made to me. My lord, I'm not going to place the entire thing because your lordship has already read it several
Yes.
times. You had entered, so it's one-on-one communication. My lord, then on investigation, kindly see, my lord, at page 117. On investigation, the complaint was found to be substantiated. What investigation? On what basis did they investigate? Investigation report? Nothing, my lord, ever given to us. Vague. The dealership had violated so and so. So they had already concluded that I was wrong, even before an inquiry could take place. Then, my lord, constantly the gentleman is communicating with me. And then, my lord, kindly look at the bottom. You reiterated the following during the said personal hearing.
Yes.
You have not entered. So all first person information, my lord, as if one person is conversing with the other. It is not that, my lord, he is communicating the decision made by somebody else. He is the one, my lord, making the decision. The entire tone of the, my lord, letter is the same. In that context, my lord, I'm placing this. And then, my lord, kindly see the last. Page 119, the last paragraph.
Yes.
After considering all the correspondence, so and so, so and so, so and so, the corporation is of the view that you have contravened the dealership agreement dated so and so. In view thereof, the corporation has no alternative but to terminate you. This letter is without prejudice to rights of the corporation. And yours sincerely. And then, my lord, kindly see. For on behalf of the oil corporation, and he signed. So he is communicating with me one-on-one. He is telling me you did this, you did this, you did this. And therefore, the corporation is terminating you. And then who's the corporation? He says, I am the corporation.
Yes.
And he signs on behalf of the corporation. So the impugned order, my lord, is his order.
Yes.
And it has to be read, my lord, as it reads.
There was a document which shows
Yes,
that.
I'm so grateful. I'm coming to that. Now, my lord, in this context, kindly just take a look at, my lord, the affidavit in opposition filed by the oil company. And, my lord, kindly take paragraph 27 at page 24. This was in response to my paragraphs 45 and 46, where I had said that this order is passed by this officer who was the prosecutor. My lord, this is the affidavit in opposition of the respondents 1 to 6. We have an unaffirmed copy, my lord. I believe your lordship will have the date.
সাজিয়ে দেবেন না? Yes, affidavit in opposition. Subrata Mollik. This is one. Subrata Mollik. Yes. This is affidavit dated. Which is the date of opposition is?
My lord, they would know, my lord. The oil company will.
It's by on
Subrata
Subrata
Mollik.
Mollik.
Yes, your lordship. Subrata Mollik.
Subrata Mollik.
Yes, yes. It's an affidavit. Affidavit in opposition.
Yes,
It's the first page. The next page.
Subroto Mallik. Yes, madam.
Yes, Subrata Mollik.
Subroto Mallik. Yes. Kindly, my lord, take paragraph 27 at page 24. Is your lordship there?
Yes.
At the bottom, my lord, paragraph 27.
Yes, I deny the reputation. Yes.
It starts with reference to allegations contained in paragraph 44, 45, 46. Now, I'm not placing 44, 45, 46, but my case here was that the same person who prosecuted me has signed this. He has communicated, he has passed the decision. Now, my lord, kindly see. I deny and dispute each and every allegations contained therein, save and except what are matters of record. So he is not denying what are matters of record, which includes the order. I deny that the impugned order of termination is not only in gross violation of principles of natural justice, but absolutely without jurisdiction. Then mark this, my lord, the next sentence, very critical. I deny that the Deputy General Manager RS is not the competent authority to terminate the dealership. He is the prosecutor who has signed, and they are denying my contention that DGM RS is not the competent authority to terminate the dealership. Then I state that the termination was not made under the, so there's an admission that the guidelines were not even looked at. And that such guideline has nothing to do with the termination of dealership of the petitioner.
We stop here, Mr. Ratmani.
Yes,
Original side matters. We'll conclude on the next date.
Right.
Heard Mr. Rachit Lakhmani, learned advocate for the petitioner.
My lord, for sake of continuity,
Yes.
may I pray for a short, my lord?
I'm finding it out so that we can conclude it over.
Yes, my lord. My lord, another 40 minutes or so, my lord, I'll finish.
Due to paucity of time, here it could not be concluded. List this matter on. ফাঁকা থেকে ডেট বলুন, দুটোর সময় নেব, দুটো কি তিনটা? 29th? 29th? Thursday? ঠিক আছে। 29th Thursday, 3 p.m. Thursday, 29th Thursday, 3 p.m.
Written notes of argument.
Okay. You also prepare your points of argument and
Yeah, Miller, because they have argued everything that they had to.
Yes, yes.
So
conclude on that day then.
I will finish.
On,
I will
3
come
p.m.
give the note. I'll run through my note and finish.
3 p.m.
Grateful.
3 p.m. My lord, your lordship is keeping it or 2:30. My lord, today it was at 2:30.
3 p.m. on Thursday. Today is Friday.
On Thursday. Let's hope, my lord, everybody is alive from the bar. That's why.
Original side. Yes.
But I'm so grateful to your lordship that lordship, considering the urgency of the matter, has fixed it today. My lord, kindly, my lord.
Yes.
May I, my lord?
Leading me in this matter, the matter was fixed yesterday. He's not in the town. So I'm trying to adjourn.
Let us first hear.
Yes, absolutely. Kindly, my lord, comes to
I have one respectful submission. I have two new applications.
GA15.
Kindly take it up, Miller.
GA15 is kindly, my lord. My lord, who is he appearing for? My lord, just kindly, my lord, ask him to ascertain, because I am interested in the proceeding. I am the petitioner. Who is he appearing for?
My application is GA20.
No, who is he appearing for? Is he a party to the proceeding? That's the most important.
Before your lordship's time and again, my lord, grant me an
It a call
opportunity of
application.
But I have not been served.
No, who is he appearing, my lord? If he is an interested party,
My
probably he is appearing for the receiver.
Yes.
If,
GA24.
না না তুমি
24 টা দেখি
appear
দেখি
করছো?
কি লিখেছে
I shall satisfy this court.
If he is appearing for the
24
receiver, then he has no right of audience, my lord.
No,
what is your application number
GA24, my lord.
24 দেখো কি লিখেছে
I have not been served.
GA24.
15 is filed by you
Me.
you
And also
And
Mr. Mitro's client.
For petitioner number 4 in the main application. And we had
No, did you file any GA application
no.
May I file my notice of motion?
My lord, he has not told me, my lord, kindly, my lord, is the best, my lord. If I may put this question, my lord, to him, who is he appearing for? If he is appearing for the receiver, of course, then he has no right of audience.
No, he says that this petition 24 is filed on behalf of respondent Srimati Charusila Trust Estate.
And represented by, my lord, kindly look into. My lord, it's extremely unfortunate that, my lord, a receiver who has been restrained by this honorable court from doing anything, now, my lord, is, my lord,
Only
trying to,
bank accounts, not anything. Only bank.
That's great.
Not everything. And that too is in
Now,
order.
authority to represent, my lord, the trust, my lord, I was, my lord, questioning. How can the receiver, my lord, what was the function, my lord? Let him show the power given to the receiver, whether the receiver was given authority to, my lord, act on behalf of the trust, and, my lord, what is the order restraining him? Now, my lord, it's unfortunate, my lord, that a receiver, an officer of the court, my lord, is trying to intermeddle in the affairs of the trust.
Correct.
I have two respectful submissions. I shall satisfy your lordships that the receiver can represent respondent number 2, number 1. Number 2 is, my lord,
Respondent number 1 is?
Respondent, the sole respondent in this matter, my lord. The second issue is, my lord, in an adversarial system of justice, there cannot be a one-way traffic between the petitioner and the court. My lord, someone should represent, my lord. Otherwise, let the name of the respondent be deleted from the array of the defendant.
Who is he to say this?
Make it a desirable order.
The receiver cannot say this.
Kindly grant me an
Kindly
opportunity.
let
I
him
shall
show,
satisfy your
my
lordship
lord, the
that I
authority
have
of the receiver.
authority to represent. my lord.
Yes, kindly show that.
I shall.
Kindly show that.
First of all, you were removed, the matter went up to division bench.
Yes.
Division bench affirmed the order of the single judge.
Not affirmed, but affidavit exchanged, my lord.
What is
directed for hearing
the
of this
motto
matter.
behind appointing a receiver?
And may I, my lord?
Is
My lord, I
it so
shall
that he
satisfy.
stands as a respondent, or is it so that he assists the court
Yes.
as per the necessity arises in the proceedings?
Yes, my lord, may I kindly grant me an opportunity? I shall satisfy your lord.
This cannot be that you being appointed as a receiver, you appear on behalf of
I
the
am
trust.
fortified by Supreme Court decisions that I can represent. my lord. Kindly allow me to submit. my lord. Kindly.
Counsel also. Seeing the
He is
contact,
otherwise he is going.
the contact of the receiver.
These are all irrelevant for the purpose of determination. My lord, may I place the honorable decision?
The difficulty is that
May I place the decision?
difficulty is that I tell you, for the last 3-4 months, whenever this matter is taken up, either the petitioner with GA15 is pressing his application. In the meantime, you intermeddle and say that I have also filed an application. It is quite difficult for the court to ascertain which of the application is to be taken up.
Yes, my lord. Let the motions be taken up first.
First of all,
Let
you
the
take your
motions.
chair. Let us see what is in the 15. If it is required, we will call for the affidavit in opposition. If not required, we will hear and dispose of the matter one by one.
I'm so grateful to
My
you.
lord, I have one,
carry on.
my lord, just one humble submissions, my lord. My lord, GA15, an order has been passed in GA15 applications, my lord, against which, my lord, I have taken out a recalling application which is appearing as GA17. In the event, my lord, my GA17 is allowed, my lord, it would affect the GA15 hearing of the GA15
Let us
application.
see first 15 what is there in 15.
Lord,
We'll definitely take your application.
Kindly, my lord.
My lord, and
Will
one
not allow.
further submission, my lord, 15 application has not been served upon me as well.
It's not
What
required.
are you?
Not required. We'll see in the
Kindly-
proceeding. Yes.
kindly,
And
my lord,
who is he
say,
also?
Today there is some urgency. because
Mr. Mitro is appearing for
but Mr. Mitro is appearing for 1 and 1A and 1B, and I am for 2. Lordship can hear Mr. Mitro also. He is senior to me.
But I am appearing for 4. Your Lordship will give me 5
Milord.
minutes. Milord, just this order, Milord, kindly. I want to.
Yes.
My lord, kindly comes to the prayer.
Bhattacharya, this is my request to you. Please take your chair. Let us. No. You
Very
take your chair.
unfortunate.
Asked by your Lordships, Milord.
Very unfortunate. Kindly comes to, my lord, the prayer, page 12. What I have prayed in this GA.
I took kagoz down.
I am grateful to your lordship.
My lord, your lordship had passed an order on 7th of August, my lord.
Kindly come to page 12 of my application.
My lord, copy has not been served as yet to me.
Page 12. Page 12, lordship has got it, my lord, the prayers.
Madam is appearing for whom? You are for whom? You are appearing for whom?
Well, I'm appearing on behalf of the Balananta Trust. I said, my lord,
I simply wrote a letter that you please show us the Vakalatnama will.
I am ready to.
Then why should we give a paper to someone who is? And there has been orders on.
This application will never be heard, my lord, GA 15. Though orders have been.
But in this intervention, each side blaming it on me. Now I'm having a very bad face before the court because the court has passed an order. I wrote a letter. Outside the court. Why should here? The court will not function. The court will not operate as the sovereign.
May I say one thing?
May I?
No letter has been given to me.
Is this the way to do the matter?
No letter has been given to me.
How to
As yet, my lord, let them show the letter. Let them show the letter that it has been served upon me. Let them show the letter that they have served upon me. I would have produced that. My lord, there is a problem, my lord, aroused.
This is the letter.
My lord,
You wrote the letter.
when? When?
Innocuous letter.
When? Where is the copy that I have received it? Where I have received it, my lord?
What is your name?
Vaishali Ghosh.
I'm not Ghosh, first of all, I'm Vaishali Ghoshal.
Ghoshal. I'm sorry.
Where is the endorsement of mine that I have received it? Let them know that I have never received such a letter. I have never.
This has been sent by post.
But I have not received it as yet.
Let us show it to us.
Well, I am sitting in the bar.
Because every time she is claiming, but Balananda, the main thing, Balananda Trust never responded when we made a public advertisement pursuant to court order on the newspaper.
Why should
Nobody
we?
came.
Because
all of a sudden,
not at all sudden, my lord. From the beginning, I was there, and
Okay.
from 2015 the
I do one thing. I call for a report from the registrar.
Lordship.
Whether Miss, what is your name?
Vaishali Ghoshal, my lord. Yes.
Has filed any Vokalatnam on behalf of the trust or not.
My lord.
If it is suffices, then you give a copy.
In the meantime, may I, my lord, just grateful. Kindly, my lord, come to page 12. Page 12, my lord, the prayers. I will show you the averment. Let me, my lord, place the prayers. This is relating to a very well-known, well-reputed trust and what has been prayed in the application. A. Formation of Committee of Management and Administration of Srimati Charushila Trust Estate in the light of deed of settlement dated March 11 to 1938. Then direction upon the petitioner as to the preparation of notice in the light of paragraph 19 here and above, and the same be directed to be published in 2 widely circulated newspapers in Calcutta and on such term as this Honorable Court may deem fit and proper for inviting objection, if any, from any concern. Now, may I pause here for a moment, my lord? This order has been passed. Twice we have done it. I will show you from the order. Then C. Upon formation of the committee, the present receiver will discharge and all affairs whatsoever relating to the said trust be vested upon the new committee of the management. That stage has not come. Receiver is still there, though he has been practically suspended, restrained from operating the accounts. Now, prior to discharge, the present receiver be directed to file an accounts with regard to the income and expenditure. So the principal prayer, what it appears, is for the formation of the committee so that the trust can function properly. And for that, prayer B has been granted. Now, kindly, my lord, comes to the orders appearing at page 94 onwards.
Before going to that,
Lordship.
show me the order suspending him to operate the
Yes,
bank account.
yes. Now, I will show you, my lord. Kindly have a look at this, my lord. It's with me, my lord. 2 orders. Akbar, that. 16 July. I only have a copy of this order. Kindly have a look at this order. And what is very important, after the order, after this division bench order, kindly have a look at the order of 16 July. May I, my lord, place it? A copy of the application being GA number 18 of 2024 may be served upon the learned receiver as well as the respondent. Learned receiver appears today in person and challenges the authority of this court to hear this application in view of the fact that the suit is of the year 1987 and the determination belongs to a coordinate bench. So receiver questions the authority of the court as an officer of the court. Very strange. However, Mr. Mitro, learned senior counsel, submits that this is an application for recalling of an order of this court. So the matter can be heard and should be heard by the bench itself. Let the affidavit in opposition be exchanged. Then that's important. The court notes submissions of the receiver challenging the authority of this court itself. Affidavit in opposition shall be filed within 2 weeks from the date, then reply in matter will appear. The next paragraph. Considering the nature of the allegations contained in this application, the present receiver is restrained hereby from operating the bank account of the trust property and is also restrained from involving into or handling any financial matter of the trust property. It's a very important order. Officer of the court, receiver appointed, court imposes a restriction. Now, I told your lordship, my lord, that there's an order of division bench also.
Yes.
Kindly turns over the next order. Kindly see. The division bench took very serious note of this fact. The receiver's audacity, that is the exact language of the order. And the court says that the matter has been referred to the Honorable Chief Justice and steps have been taken and referred to the Bar Council. Probably this has never happened before. Page 8, May 8, 2025.
Yes.
Lordship has got it, my lord?
Yes.
May I? So review. Review is sort of this court's order passed by a coordinate bench. By the said order, the coordinate bench had declined to interfere with the ad interim order passed by a single bench dated 16 July 1924. The said order was passed in an application by the parties to the suit for removal of the receiver. As an interim measure in exercise of the discretion under Order 39, Rule 1 and 2 of CPC, the court deemed it fit to restrain the receiver appointed by it not to operate the bank accounts of the trust, the order which I have shown you. Now kindly turns over. The ground for which the review of the order dated so-and-so is sought is that the earlier division bench had failed to consider some of the propositions of law and the decisions of this Honorable Supreme Court. Then, it is now well settled that even an incorrect order contrary to law, if passed, does not attract the provisions of Order 47 of the CPC. The only ground on which a review application can be filed is there if there is error apparent on the face of the record and if any new evidence hitherto not available to the parties or any subsequent event has come to light. Now, these facts, my lord, I will not trouble your lordship. Kindly comes to paragraph 9. Before parting with the application for review, it is brought to the notice of this court by the respondents that the signature of the receiving advocate on the notice of the application for assignment of the instant review application is forged. The said advocate, Mr. So-and-so, present in court, has vehemently denied that he has signed or received the said notice. The letter dated so-and-so is kept on record. Now kindly turns over. A copy, lordship has got it, a copy of this order shall be placed before the Honorable Chief Justice for appropriate orders against the receiver as the Honorable Chief Justice may deem fit and proper. Have you, my lord, ever heard, my lord, have we ever heard of it? An officer? The receiver is an extended hand of court. He is an officer. Division bench took such a stand and referred it to the Honorable Chief Justice against an officer of the court. When can it happen? And I'm told by my advocate on record, the proceeding is still pending in the Bar Council. Steps have been taken. So this is the character of an officer of the court. I'm so sorry to say this because I am also an officer of the court. I have some responsibility towards the court apart from handling the case of my client. This probably hardly has happened. Now that gentleman is shouting. And what he did in the interregnum, my lord, I will tell your lordship, he has transferred one of the properties, indicating that he is the owner of the property. He has parted with the possession. It's a shocking thing. I will tell you. I know the shouting will come.
My learned friend gets it on the record. He did not say anything out of the record.
Now, lordship.
Misfit the court, my lord. That's all.
Yes.
My lord, he must all place on the record.
Now, kindly comes to, lordship wanted to see the order restraining the receiver. I have shown you, and the order of the division bench. Now, what
this order, that is original order passed by the division bench,
yes,
against which 16th July 2024 this appeal was referred, that order is with you?
My lord, I have a copy of this order which I have handed over. 16 July 2024 is the first order.
First order.
And the second order is the division bench order. That is, my lord, dated 8th May 2024.
No. In the meantime, there is a order passed.
Yes.
Against which this review comes.
Yes.
Okay.
Yes, 1st October's order, lordship wanted to see. Lord, I can hand over, my lord. Kindly have a look at this order. Today, my lord, we are concerned only about, my lord, the functioning and smooth administration and running of a trust. That's why the formation of a committee has been prayed for. Receiver has been appointed to protect the interest of the trust and to act in terms of the order of the court. He is not a party interested in the proceeding. You can't be. You have to act only in terms of the order of the court.
Yes.
Lordship has seen the order. Now, my lord, kindly comes to the orders passed on this application, because I will be praying for the formation of a committee. Page, my lord, 94 onwards, the orders. Kindly come to page 90, my lord. Annexed if. Twice, my lord, the order for publication has been made in terms of prayer B. I submitted before your lordship. Now I have to justify. Order of Justice Sain Miller, dated 7th August 2017. Lordship has got it?
Yes.
My lord. May I place this? The petitioner number 1 has filed this application for constituting a board of administration and management. Kindly see the date in 2017 this has happened. Of Srimati Charushila Trust Estate. The petitioner says that so-and-so, 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 and so-and-so have all died, and the petitioner is the only surviving person directly related to the trust for the last 30 years. The petitioner number 1 claims to be the only interested person to continue with the trust. The petitioner suggests that the petitioner number 1, Mr. Tapan Ghosh, Mr. Kaushal Kishore Rai, Mr. Ashish Rai, Ranjan Roy may be appointed as a board of trustees for administration of the trust estate. Then, the petitioner shall serve an appropriate notice upon so-and-so of Mohendro Srimani Street, Calcutta 9, and Mr. Chanchal Bose, 270 BT Road, Calcutta 36, in course of this week, with an intimation that this matter shall appear in the list on 18 September 2027. Then, my lord, kindly turns over. The paper publication I just, my lord, indicated. Since the trust appears to be a charitable and religious trust, in my view, the petitioner shall cause notices to be published once in the Statesman and once in the Bortoman, having wide circulation in Calcutta, informing all concerns that the following persons are proposed to be appointed as trustees. The names mentioned who are proposed to be appointed as trustees, and there was a direction to paper publication. An important thing, kindly see, any person interested may appear on the returnable day and make appropriate submission. So we made the paper publication, that's on record, that has been done. Only one, Kinam Boishali? Mrs. Boishali Ghoshal appeared, but unfortunately till now, and Lordship was so kind enough to pass that order, could not produce any document, the authority. When I appear on behalf of somebody to indicate that I have some interest, to place my case. First, I have to show that I have an authority given by the client. That authority has never been produced. This is my instruction. Lordship has directed. Hopefully, it will be produced because this protest has been going on for some time without any proper document, without any proper authority filed in court. That's the position. Now, my lord, kindly, my lord, turns over to another order of the division bench, which is at page 107, just to show the conduct of the receiver. And after that, I will show, my lord, the order of another coordinate bench by Justice Mojumdar, Sugata Mojumdar, whereby another order for paper publication was made, and we complied that. Page 107 is the last annexure. Another order by the division bench, a different division bench. Kindly see the observation. We have heard out this appeal, dispensing with the formality. This is an extraordinary appeal. The receiver who was discharged by the learned single judge has preferred this appeal against such discharge.
This is not related
The
to this
receiver,
receiver.
the receiver is an officer.
Is the earlier receiver, my lord. This is not.
The receiver is an officer of the court, discharges his duties at the pleasure of the court. Then whatever, my lord, is there, kindly, my lord, comes to the page 108. 108. Kindly, my lord, reads the paragraph, my lord. The court deprecates. Lordship has got it, last 4 paragraphs. The court deprecates most strongly that this act of the receiver appropriating money to himself towards his remuneration without any order of the court. Nevertheless, we note this, that the allegation is not reflected in the impugned order. Then, in that view of the matter, leave given to the outgoing receiver to apply the learned single judge to claim the remuneration payable on his discharge. So on that thing is that happened. Why I placed it? Just allow me, please, Dada.
Yes.
After that, the receiver was discharged. Earlier receiver. Then another person was appointed a receiver. He did not want to continue. Then the present receiver, Mr. Gupta, came in. That's why I wanted to show you this order. This is the position. And remark of the division bench relating to the act of the present receiver, I have shown you, and also the observation of the single bench. Now kindly comes to the order of Justice Mojumdar, my lord, another order, whereby, my lord, on what terms this receiver has been appointed. Page 105. Page 105. I know, my lord, 3:30. Just give me 2 minutes. 105. On what terms this receiver has been appointed? 26 February 2024. Lordship has got this order. Mr. So-and-so, learned counsel for the newly appointed receiver, candidly submitted. In fact, I appeared for that receiver, submitted and reiterated that newly appointed receiver, Mr. So-and-so, may be released from assignment. He handed over the check. Check was given. He was returned. Then, kindly skip the next paragraph. Next paragraph, my lord. In view of release of Mr. Roy, no one is there to administer the estate of the trust. Mr. Mitro for the plaintiff submitted that Mr. Ashok Gupta, advocate of the member of the Bar Library Club, may be appointed receiver in place of Mr. Roy. Let Mr. Gupta be appointed as a receiver as a stopgap measure. As a stopgap measure. Since a review application GO1 of 2024 with review is pending for adjudication, appointment of Gupta is subject to outcome of the reviewer. So he's not even appointed on specific terms. As a stopgap, since there was nobody to look after the interest of the trust, an advocate of this court has been appointed as a stopgap measure.
Subsequently,
then immediately he was restrained. He was restrained. Now, my lord, kindly comes to
review 6.
Review 6. Lord, the erstwhile receiver filed the review application. Yes. Erstwhile, that was pending at that point of
Now
time.
it has been disposed of.
Disposed of. But Mr. Gupta has not been appointed permanently. So this order remains. He has been appointed as a stopgap with the subsequent rider that he has been restrained, seeing his conduct. Earlier receiver goes, new incumbent comes in as stopgap. Then an order of injunction has been passed, restraining him from operating any of the bank accounts. Of course, after seeing the conduct must be.
So tell me one thing, that this application, any publication will be required.
Twice made. I don't think any further publication is required. Twice publication has been. My lord, there's an order I showed you, Justice Sen in 2017. Then there is another order. It's part of the application. But my junior has given me another order for publication.
Those applications have not been disposed of because the prayers made in the present application is similar to what is made in the
My
17
lord, the
application.
formation of the committee could not be made. Why? Even after publication, somebody stood up and said, I object. Very well, court has to hear. It's a public trust. That gentleman or the lady or the client could not produce any document. I will show you on the next day till now. So obviously there was an objection, and without an authority, court could not have formed the committee. In the interregnum, the receiver was discharged, new incumbent comes in. So practically the purpose for which the application has been made has been stalled. And there is no committee as such. That's the urgency.
Let the publication be made.
But already done.
This application.
Kindly have a look at this order. Again.
In terms of this prayer made in prayer.
My lord, again this has been done. If lordship wants, third time we will do this. Kindly see, again this has been done. Second, twice. Kindly seize this order.
In this application?
Yes.
Then it's all right then.
Twice done, my lord.
15
Kindly seize this.
GA 15.
So after twice this has been done, I don't think any publication is required. Okay. Now what is important, lordship has to see and decide whether the formation of committee has to be done. If it is done, who would be the committee of members? Okay. Now may I come back on the next day? Because now, my lord, trust cannot function. Lordship has seen the restraint order. Yes. Any day, my lord, lordship, when it's convenient to the court, my lord, kindly decide this, my lord.
My lord, some allegations have been made against and some order has been placed. My lord, kindly grant me an opportunity so that I may bring to your lordship's notice, my lord, the actual facts involved in this matter, my lord. My lord, one further submission, my lord, Mr. Dev appeared for the receiver. Now he is appearing for the respondent.
Lord, senior advocate appearing on behalf of the petitioner.
Now he is appearing for the petitioner. My lord, kindly note this fact as well.
Where is your supplementary affidavit?
Yes. Supplementary affidavit, I think it has been filed. Yes, my lord. This is the supplementary affidavit. May I, my lord? This is the supplementary affidavit on the last day lordship directed.
Supplementary affidavit filed by.
It takes it on record, my lord.
You are applicant of 15.
15. My lord, Mr. 15? Mitro is also. I am for my lord 2. And Mr. Mitro is for 1 and B. He's my lord for the lordship will hear him also.
Kindly give that.
Yes, absolutely. Absolutely.
Senior advocate and Mr. Mitro, senior advocate, Aage Devan. Appearing for the applicants being plaintiff number such and such.
But 2.
Plaintiff of 2 and Mr. Mitro is for 1.
1A and 1B probably, my lord.
Mr. Mitro, you are for 1A and 1B. 1A, 1B. Supplementary affidavit filed by the applicant is taken on record. Mr. Mitra along with Mr. Senior Advocate submits that. Please. Submits that. The present application has been filed for formation of a committee. Since orders have been passed by the single judge restraining the receiver who has been appointed as a stopgap measure from dealing with the bank accounts. Ms. Boishali Ghoshal, learned advocate, submits that she is appearing on behalf of
the Balananda Trust.
Balananda Trust, but the copy of the application has not yet been served. Mr. Debujyoti Basu, learned advocate, appearing for the
petitioner number 4, Chanchal Bose.
Petitioner number 4, Chanchal Bose, submits that letters have been issued to the learned advocate Srimati Boishali Ghoshal requesting her to intimate her authority to receive such application. However, till date, such has not been received. In view of such circumstances, registry is directed to Ms. Gosal submits that the copy of the application has not been served upon her. In view of the above, registry is directed to furnish a report regarding the authority and or affidavit, Vokalatnama submitted on behalf of Balanando Trust by Srimati Boishali Ghoshal on the returnable date. Follow. Sixth.
Where I was appearing for 3 and 4.
3 and 4. Mr. Basu for 3 and 4. Where is Mr. Dev?
My lord.
On 6th February.
Very well. Only one difficulty, my lord. I'm not making any prayer today. On the next day, lordship would consider, after this restrained order, unless, my lord, one of the petitioner is directed to, my lord, make some disbursement relating to the fund.
That we decide whether it will be petitioner or any other.
I'm not pressing. I'm not pressing for that.
Independent person will be upon that. Will
Very well. Very well.
My submissions be recorded.
Bank account is to be operated in the.
Very well.
Let my submissions be
I'm not
recorded, my lord.
My lord, may I just pray for one indulgence? My lord, in GA, I'm sorry, my lord.
They are made, my lord, at the top, my lord, on that day, my lord.
No, it will be taken up. Don't.
My lord,
Great.
my lord, let my submissions be recorded, my lord. In view of your lordship's this order, my lord, I want to make submission, one respectful submission. my lord.
Make a
Passed
submission
by
of this.
6th August 2024, my lord.
My lord, I am the applicant in GA.
Concluded, you will make your submissions on
I am the applicant in GA
My lord,
13.
with reference to your
I am
lordship's
the
order.
applicant in GA.
Yes, Mr.
My lord, I am the applicant in GA 13
Hmm.
of 2022. My lord, I'm only praying for prayer C. Kindly allow me to implead, my lord, a trespasser of this trust as a party, because I am a tenant. He has trespassed into a small portion of my property. My lord, I am praying for him to be removed.
I want to rely on your lordship's order passed on 6th August, my lord. Kindly have a look at my lord.
6, it will appear at 3 p.m. my lord. 3 p.m.
3 p.m.
Grateful. Great.
My lord, may I be permitted to mention? I have already filed. Your lordship told that transfer matter, my lord.
It will be listed. Regularly, it will be listed when you take it up.
We have to join,
No.
my lord. That's why the
No.
urgency. My lord, it
No
may be
urgency.
taken up on Wednesday or
No,
Thursday,
sir.
any day, my lord.
No.
Next
Sorry.
3 months.
I'm grateful.